May I please, Your Lordship?
Yes.
My Lord, I have been clear for 12 of item number 16, 17, 33, 34, 35.
We'll allow you to withdraw it when the matter is called.
My Lord, oblige.
Which one, item number?
Item number 16, 17, and in the supplementary list, Lordship, 33, 34, and 35, Lordship. Here, Lordship, some of the petitioners have already been appointed, Lordship.
We'll see. After the orders of this court, how were they appointed?
My Lord, here, Lordship.
You went up on appeal also.
No.
Appeal also rejected.
Yes, my Lord.
Let the matter switch. We'll see how the respondents are doing it.
Yes,
And if required, I'll recall all my orders of
earlier petitioner was
we have decided the matters. And if after that the government has appointed, we will have to know how they were appointed.
No, in another department, Lordship.
Wherever it is.
In another
Wherever it is, we'll have to know from the government how it was.
Not under the compassionate scheme.
Yeah, let the matters reach. We'll see.
My Lord.
Not under compassionate appointment.
No, not compassionate appointment.
Normal appointment.
Normal appointment. Under AJ scheme, Lordship, some of the petitioners have already been appointed, Lordship.
Okay.
So they are no longer interested.
Okay. When the matters reach, tell me.
May I please, Your Lordship? I beg to item number 5, Your Lordship, with the consent of other side, Your Lordship. I am on behalf of Mr. S. Ali, and he is unable to reach the court due to flood problem, Your
The
Lordship.
flood has subsided.
Yes, Your Lordship. With the consent of other side, Your Lordship. The matter may be come up any day. Next week.
You were provincialized by, you are not in the case.
No, Lordship.
Have you taken the consent of the petitioners?
With the consent of other side, Your Lordship. We have informed.
A prayer is made on behalf of Mr. S. Ali, Learned Counsel for the respondent number 7, with the consent of the counsel for the petitioner, for an adjournment in the matter on the ground that he is not in a position to attend court on account of floods, on account of personal inconvenience. Also, prayer accepted, registry to list this matter again on Undinapari 304/2026.
Lordship.
My Lord, item 4, my Lord. This was about provincialization of madrasas, my Lord. Well, become infractious now because withdraw with liberty, my Lord.
What liberty?
Lord, under the 2007 Act, they want to move the court, my Lord. The reorganization of this has.
Okay, let the matter reach. We'll pass the orders.
My Lord.
Your Lordship. I'm praying for listing of a matter for withdrawal. Tomorrow, Lordship. Publish.
Listing of matter, my Lord.
Listing matters,
Yes,
give it
for withdrawal.
motion.
No, no, my Lord. Admission. 22. Oblige.
For withdrawal, Lordship, 1 month more.
My Lord, with the consent of the petitioner, I beg to mention item 6, my Lord. Let this matter be come up on Friday, my Lord, because the petitioner has requested to fix the matter on Friday, my Lord. Yes, sir.
You have not filed an affidavit here. Have you filed? 6 of such an affidavit assignment.
Actually, this matter has been
This is with regard
conducted by
to
DU Pomeno here.
they think that she is absent from 2005. Right? 2005 is a very, year 2005, insofar as colleges are concerned, it's a milestone.
Yes, ma'am.
Where was the services provincialized?
Yes, madam. Well, I have no, I don't know the details of the matter, madam, because the DU Pomeno was conducting the matter. He has some medical difficulty, madam, today.
Who?
DU Pomeno, madam. DU Pomeno.
A prayer is made on behalf of Mr. D. Opomenu, Learned Counsel for the Learned Standing Counsel, Higher Education Department, for an adjournment in the matter on account of
Some medical license, madam.
certain personal inconvenience. Prayer is not objected to by the Learned Counsel for the petition. Registry to list this matter Thursday?
My Lord, they have even considered for Friday.
Thursday.
Friday, Lordship.
Thursday.
Much always.
Okay, 24/4/2026.
Please, the Lordship. Lordship, I beg for listing a rate petition, Lordship.
Motion.
No, Lordship, it's a pending matter, Lordship. It was last posted on, Lordship, 28/11/2025, Lordship.
Lordship, I have a similar prayer for listing of a writ petition for admission, Lordship.
What is the matter?
Lordship, the matter pertains to non-payment of teacher's salary. The matter was fixed on 10th of April. Since it was a holiday, Lordship, the matter.
Okay,
All right, Lordship.
next week, DD.
Please, Your Honor.
All these matters are same.
All are same, madam. Now that
Now tell me one thing.
he was supposed to
24, 25, you were not permitted.
24, 25, I was able to. 25, 26, I was not able to. Now I am here for 26.
No, but the challenge you made to 1/4/24,
Yes, my lord, there was an interim direction. I
so
was
you submitted.
Yes.
Then what happened in 25, 26?
No enrollment, my lord.
Huh?
I was not able to. What happened is.
So 25, 26, you were not able to.
No, I filed an IA impugning that particular notification of 25, 26. At that point in time, this honorable court disposed of the matter and allowed.
Okay, so 25, 26, you are not in the fray.
No, and it was not.
So- Who is appearing for the government here?
My lord, I am appearing for as per number 4.
You will act only when the government gives the permission.
Yeah,
Yes, why the permission? There was a categorical direction from this court, why it is not being done? You obtain your instructions, we'll take it up after some time. This last date is tomorrow. And this order was passed on 28/4/25, and you are sitting over the matter. Now, today we permit the college, school, or the college, whatever it is, to admit students. Tomorrow you reject that. What would be the fate of the students? You're playing with the life of the students here.
my lord, contempt cases are pending in this case, my lord.
Fine, forget it. We are not interested. But the thing is, why is the matter being pending? The feasibility report is with you. Take a call either way. We'll have it at 12 o'clock and we'll protect. If we come to your rescue, we'll protect you.
Regarding the protection, what's the
25, 26, you are not there.
the ground situation is, if the protection is extended till tomorrow, then what will happen is I won't be able to enroll any.
We will give it, we are satisfied. We will extend it for another 2-3 days. We'll ask Mr. Chutia to keep the portal open.
The compartmental exams are also coming up, my lord.
25, 26, you were not there, Mr.
I know, my lord, but the matter was.
And
reserved
these
as a-
things should not be permitted to
What
continue
will
like this.
happen is,
Ms. Musari, have your instructions. We'll take it up at 12 o'clock. Sitting over the matter for last around now 2 years, nothing is being done. Why? These orders of this court have got no value? Or you have to have a contempt for that? We will ask them now. That contempt we will call up and we'll ask them their personal appearance to. You get your instructions. Yes. What is that?
My lord, we need some time. Actually, my lord, one file has been processed for payment of some arrears salaries. Probably that has been paid or not.
No, my question is.
Yes, my lord, I
he was
understand.
given 2 promotions.
Yes, my lord.
Whether both those 2 promotions have been reckoned for fixing his pay.
Yes, my lord. In terms of your lordship's last order, my lord, I have communicated exactly that instruction I have sought for, my lord.
Mr. D.P. Bora, learned, Standing Counsel, Health and Family Welfare Department, submits that the matter is being processed for issuing by the respondents for issuing instructions to him with regard to the query raised by this court by the order dated 26/3/2026. Accordingly, he prays that the matter be taken up on when? 4 weeks is too much.
My lord, actually, because it
We
is.
are only one whether you have taken.
Yes, my
that.
lord. That's why they have requested me. They need some time
They
because
don't know.
old records, my lord, they have to
But
find
this
out. my
matter
lord.
is pending from 2016 and you have not done that
My
exercise.
lord, I will try to find out, my lord. So
We will
sometime.
impose cost now. 2016 onwards, you are not doing anything. What is this, Mr. Bora? A man, retired man is before us praying that give me what is my due.
Yes.
You have given him, but you are not releasing the consequential benefits.
No, probably the file has been processed and some payment has been made.
We don't want these probabilities. We
Yes.
want yes.
Yes,
no.
my lord, I will.
On 11/5/2025 for further hearing. I'm giving you 3 weeks time.
Yes, ma'am. Can it be on 15th, my
No,
lord?
11.
Yes, ma'am.
public.
Published, my
In
lord.
the event the instructions for answering the queries raised and noticed herein above are not furnished to this court on the next date of listing, appropriate orders as may be called for would be passed by this court. So far, the hearing quitted. Yes.
May I please, Lordship? Lordship, kindly pass over the matter for the time being, Lordship.
Yes. What is your case?
Lordship. Pursuant to an advertisement dated 5/1/2017.
We're taking it up for final disposal. Okay. Advertisement is?
5/1/2017.
I just forgot your name. Mr. Beria.
Yes, Your Lord.
M. Beria.
Yes, Your Lord.
Advertisement is at page
14, Your Lordship.
dated
5/1/2017.
some rifles.
Yes, Your Lord.
General Constable General Duty, right? Or clerk? Clerk.
Havaldar.
It is called Constable Clerk.
Havaldar. Clerk.
Havildar. Where do I get it? Appendix A.
Page 26.
Yes.
So a candidate to be placed in the merit list has to qualify in 4 rounds as per the scheme of the advertisement. Your Lordship may kindly turn to page number 16 of my writ petition.
Serial number 19.
Yes, Your Lordship. And Your Lordship may turn to page number 26, the skill test norms. Your Lordship, number 1, clerk Havaldar, skill test norms on computer. English typing test with minimum speed of 35 words per minute on computer. So that was the criteria. Now in this case, what after the exam was concluded, they have relaxed the norms from 35 words to 20 words per minute. Right?
Where is that relaxation?
They have stated in their additional affidavit, Your Lordship. Para 5.
You have to appear in both Hindi typing and English typing.
Only English. Your Lordship.
Only English. Para?
5 of their additional affidavit.
Page?
112.
Para?
5. From the bottom 10th line, as per advertisement, total 100 vacancies were advertised for Havildar Clerk, Assam Rifles Tech and Trade Rally 2017. As per result of trade test, only 13 candidates have fulfilled the prescribed criteria, that is 35 words per minute. Majority of the candidates could not achieve prescribed standard of typing test. Keeping in mind the maximum subscription of available vacancy in clerk trade, a competent authority decided to dispense the typing test criteria to 20 words per minute from required 35 words per minute as per recruitment rules. But there is no such rules that they can relax the norms once the recruitment process has begun. And these two, they suppress this fact that they have relaxed the norm till 2024. Only after this court directed to produce the record, when they produce the record, then they reveal that we have relaxed the norms. Because your lordship may kindly see my RTI application.
So your whole case is here only.
Yes, your lordship.
Okay. Where is your RTI reply?
Page 66. What I have asked from them, page 67. Sir, I am Sanjay Singh Gangola.
Wait. It's in your writ petition.
Yes, your lord.
The numberings are all 67. Please provide me photocopies, so and so. Skill test typing documents.
These were my queries. And what they replied is at page 68. Only one vacancy of clerk trade for general category was advertised against Uttarakhand. The same vacancy was filled up by appointing a meritorious candidate from general category as per the advert. You could not be selected due to low in merit. Your complaint has been analyzed. I have not made any complaint. From where they said that in the RTI reply. Thereafter, I filed an appeal. Then they replied, which is at page 71. Para 2, yeah, I'm reading the relevant. It is to inform you that the Assam Rifles is exempted from forwarding information sought by you under RTI Act as per section 20.
Then what happened?
Then I again made complaint towards CDRS. Thereafter, I approached this honorable court.
So your case is that the respondent number 7 who was recruited against the post.
He failed in the typing.
So in Uttarakhand, he having not acquired 35 words per minute in the typing test, he should be held to be not qualified in the skill test, and accordingly, whatever marks he had got in the written examination, that cannot be reckoned.
Because he cannot be placed in the merit list.
Yes, that's the only case you have. Yes.
Here, my lord, what happened? Page number 18 of the writ petition, total vacancy in the clerk is 100, my lord. In page number 18 of the writ petition. So what happened, my lord? Is to let us use a is that
Did I hear this matter earlier?
yes, my lord. As per advertisement, total load was 35, my lord. But what happened, my lord? That is the note sheet, my lord. Power to relax for conduct of the trade test for the Assam Rifles. The reason behind that, my lord, it is submitted that Assam Technical Trade 2017 has been started up to fill up 614/35 trade with effect from so and so. The trade test for the post of holder of the subject really was scheduled with the 19 July 2017 onward so and so. Here, my lord, kindly see in serial number 0 to 99, 84 candidate who did only 0 to 99, my lord. 9.9 or above 35 only 35 candidate or 13 candidate. Then what happened, my lord? The reason behind that, my lord. Rule for the position for Hawaldar clerk, the typing of the minimum speed 35 per minute of the computer, Hindi typing minimum speed 30 word per minute, computer so and so, correspondent to so and so, required. As per result of the trade test, a typing test as mentioned at the para number 2 above, only 13 candidates have fulfilled prescribed criteria, that is 35 WPM. Total 100 vacancies were advertised for the Havildar clerk trade for AR technical and and the recruitment really 2017. After written examination, filtration was done and the candidates were called for DME and trade test 1.10 vacancy. During AR technical and the recruitment really 2015, total 88 vacancies were advertisement. Only 42 vacancy could subscribe from across the country. In order to max participation and the optimum station for DME, it was decided by the competent authority that the candidate who have achieved 20 WPM speed in the type test be allowed to appear in the DMA. And that has been done, my lord, as per relaxation para number 8 of the RLL. And that is in our additional affidavit in page number.
Just a moment. Then what happened? Then this was put up before your DG.
Yes, my lord.
And the DG
DG approved it. Yes.
14-7.
Yes, my lord.
14-7 of which year?
That is
17.
17.
No.
No,
14-7
that
of
is
17. Okay.
DG note is also there, my lord.
Then what happened? Page, where is your
117 of my additional affidavit, my lord.
para?
Para number 8. 117.
All gone wrong. This is
No, my lord, that is, yes. That is there, my lord. That day I could not show your lord.
no, this numbering is different.
Oh, numbering, sorry.
117 is para?
Para 8, power to relax. That is annexure B.
Ah. But this power is with the central government. How your DG has relaxed it?
My lord, DG relax it as per my lord.
Delegation of power.
Yes, my lord, that is there, my lord. Okay. Okay. Here, my lord, clause number 9, kindly see saving clause, my lord. Nothing in this will affect the reserve.
That is different.
Yes, well, that is, but this is the DG has the power in 2002. There was an amendment, my lord, 2002. 2002, my lord.
What is this rules called?
Recruitment rules, my lord.
Assam Rifles.
Rifles. Yes.
Rules of which year?
This is 2002, my lord. Amended.
Amendment 89.
Yes, my lord. Kindly see in the second page, my lord, column number 8, my lord. Last word, power to relax. The power to relax any of the criteria shall be with the Director General of Assam Rifles.
Okay.
And my lord, he in earlier occasion he placed one judgment, my lord, and that judgment also, my lord, if the there is a recruitment loan, then they can do, my lord. This is the judgment submitted by them, submitted by the petitioner, my lord. एक मिनट আমি কপি আছে নাই আচ্ছা in the conclusion part my lord
Tej Prakash.
yes my lord that is my submission
Yes, Mr. Dilip.
Lordship, it is a settled law that once a recruitment process begins, it cannot tinker with the rules of the game. Now,
Tej Prakash has answered that question.
now they have done that only.
It's not tinkering. It
They've
is
changed.
it is not,
And they are saying, I am
see,
doing
Mr.
that.
It is not aimed at a particular person. That is common to all. And Tej Prakash has already laid down that. And if the power is there in the rules
There
to
is no
do
power,
that,
sir. Power is that they can make change in the advertisement.
no, the
That
the power under the 2002 amendment, the power has been given to the
yes easy
DG Assam Rifles.
Your Lordship may kindly turn to page number 10 of my writ petition. There is a, as per the advertisement, there was a clause relaxation. What can be relaxed? Everything has been provided.
Page number
18.
18 is your this
advertisement
Advertisement.
advertisement, the number of vacancies.
Oh, your Lordship. Oh, sorry. In their affidavit in opposition, your Lordship.
Para
5.
para 5.
Yes. Relaxation.
Okay, where in para 5?
Relaxation. There will be relaxation in age for ST, SC, OBC, ex-servicemen and other
You're
categories
reading para 5.
of page 18 of their affidavit in opposition. The first affidavit in opposition.
Okay. This is the general relaxation.
But can they change without informing anybody?
Come to para page 96. That means page 19, sorry.
Yes.
So this power has been given.
No, but can they, after the exam,
No,
can
no,
they
that-
relax?
what is the requirement of having that clause there if it is not to be utilized during the recruitment process?
Your Lord-
Because whatever relaxation has to be given is already given. Further relaxation, if required, to take the process to its logical conclusion. That is why this is incorporated.
Your Lordship may, the power to relax eligibility criteria is mentioned in para 5. Now, what is mentioned in para 5?
Relaxation.
Height and chest. Nothing more. Not about the typing test. Nowhere it is mentioned that
Okay. Anybody appearing for the private respondent? No. Have you made him a party?
yes
yes, your Lord.
He has not appeared.
No. And I would also like to rely on the judgment of this honorable court. Here also in a similar case, they changed the rules after the initiation of recruitment process. Proceed. Otherwise, the sanctity of the advertisement will fail, your Lordship. What is the meaning of the advertisement then? If they can change it.
Okay. Anything more?
No, Your Lordship.
So if we answer this point in your favor, the appointment of the respondent number 7 will go. And then after this long gap, should we direct for your appointment?
That is not for me to decide. That is for Your Lordship to decide.
And if we decide this point against you, we need not go into any other matter. Suppose I'll pass the order. I'm keeping this for some time.
Yes, my lord.
After passing the order in the second half, you can take back this.
Lordship, the learned counsel is on leg at court 8 assisting a senior advocate. Lordship.
After Lekha. Heard Mr. J. Sharma, learned counsel for the petitioner. Also heard Dr. H. Samuha, learned standing counsel, Assam State Transport Corporation. Also, the petitioner in the present writ petition has presented a challenge to an order dated 22/12/2015, issued by the Managing Director, Assam State Transport Corporation, removing the petitioner from his services as a trainee driver with the corporation. The petitioner has also assailed an order dated 21/7/2017, rejecting the appeal preferred by the petitioner against the said order dated 22/12/2015. Also, the facts in brief requisite for the purpose of adjudication of the issue arising in the present writ petition is noticed as under. The petitioner herein was on his selection as a trainee driver was appointed in the Assam State Transport Corporation bracket hereinafter referred to as the corporation, and he had joined his services with effect from 17/3/2011. Also, the petitioner was required to operate a reserve trip from Sipai Kola to Gauhati on 23/5/2015. Also, the said trip was with regard to the flying of Congress workers who were to participate in a government function to be held on 23/5/2015 at Aforesaid Stadium, Gauhati. Also, the petitioner accordingly, as the driver, madam, you take your seat, of vehicle number of a bus bearing number AS/20-1509, flight the said passengers to Gauhati. Also, for the purpose of ensuring that for the purpose of facilitating the petitioner to undertake the said trip successfully, the station superintendent of the corporate of the Jorhat station of the corporation had handed over an amount of rupees 2,700 2,700 to the petitioner for the said trip for purpose of refueling if so required on in course of the said trip he was to undertake. The petitioner undertook the said trip and on conclusion of the same had submitted a bill of purchasing diesel oil for the vehicle in question during its trip for the whole of the amount has handed over to him, that is rupees 2,700. Para. On an allegation surfacing that the petitioner had not actually refueled the vehicle in question, the petitioner came to be placed under suspension while an order dated 23/6/2015 pending drawal of departmental proceedings against him. Also, the respondent authorities had thereafter instituted proceedings in the matter against the station superintendent of the Jorhat station of the corporation, who was also placed under suspension for the same allegations that were so made against the petitioner herein. Also, it is projected that the petitioner was thereafter via a communication dated 8/10/2015 required to appear before the senior divisional superintendent of the corporation at Jorhat for a personal hearing on 13/10/2015 pertaining to his suspension with regard to the allegations of his plying the vehicle number AS-20/1509 23 on 23/5/2015. The petitioner is found to have appeared in the said appeared for the said hearing, and his statement is also found to have been recorded therein. Also, the inquiry officer, that is the senior divisional superintendent of the respondent corporation at Jorhat, thereafter via a communication dated 13/10/2015 forwarded his inquiry report to the senior deputy general manager of the corporation at Gauhati. Also, in the said inquiry report, nothing incriminating was brought on record against the petitioner herein. Also, thereafter, basing on the said materials coming on record, the managing director ASTC of the corporation, by the impugned order dated 22/12/2015, proceeded to remove the petitioner from the services of the corporation. The petitioner preferred an appeal in the matter before the managing director of the corporation on 30/12/2015. The same not being considered, the petitioner had approached this court by way of instituting a writ petition being WPC number 2424/2016. The said writ petition was disposed of by a coordinate bench of this court wide order dated 18/1/2017, directing the consideration of the appeal preferred by the petitioner in the matter. Thereafter, the appellate authority, that is the chairman of the corporation, wide order dated 21/7/2017, proceeded to reject the said appeal preferred by the petitioner, thereby affirming the order passed by the managing director of the corporation, removing the petitioner from the services of the corporation. Also, subpara. Being aggrieved, the petitioner has instituted the present writ petition. Mr. J. Sharma, learned counsel appearing for the petitioner by reiterating the facts noticed herein above, has submitted that the removal of the petitioner was not preceded by issuance of any show cause notice to him and or holding of an inquiry in the matter in pursuance to such institution of departmental proceedings against the petitioner. Mr. Sharma has submitted that the petitioner, that the hearing which had preceded the issuance of the order date, impugned order dated 22/12/2015 was only for the purpose of was in connection with the suspension of the petitioner and not in connection with institution of any departmental proceedings against him. Mr. Sharma has further submitted that the respondent authorities have not afforded an opportunity to the petitioner to have his say in the matter after issuing to him a due show cause in the matter, leveling the allegations that may have existed in the matter against him. Also, it is submitted that even if the inquiry is taken, even if the hearing that has been held in the matter with regard to his suspension is taken to be also a hearing with regard to the allegations leveled against the petitioner, Mr. Sharma submits that the inquiry report, which is inquiry report as submitted in the matter by the inquiry officer, would go to reveal that there was no incriminating material brought against the petitioner in the matter, and rather the action on the part of the petitioner in refueling the vehicle in question was said to be correct, was held to be correct on account of the distance covered and also the requirement of running the vehicle at minimum speed and the frequent change of gears due to traffic jam at Gauhati. He submits that basing on the said material, the managing director, of the corporation, without furnishing to the petitioner a disagreement note, could not have taken into consideration, could not have proceeded to remove the petitioner from his services. Mr. Sharma has further submitted that the appellate authority, while considering the matter, had not appreciated the same in the manner required, and accordingly, only by noticing the allegation leveled against the petitioner, without determining as to whether the said allegation can be held to be established against the petitioner herein, proceeded to reject the appeal of the petitioner void the order dated 21/7/2017. Subpara. In the above premises, Mr. Sharma submits that the impugned order dated 22/12/2015 and the order of the appellate authority dated 21/7/2017 would mandate an interference from this court. Next, per contra, Mr. A. Chomoha, Dr. A. Chomoha, learned standing counsel, so and so, of the corporation, submits that the allegation having arisen against the petitioner of having misappropriated an amount of rupees 2,700, which was given to him for meeting exigencies that would arise during the trip undertaken by him to Gauhati, and also submission of a false cash memo from a depot in Meghalaya, the petitioner was placed under suspension. So he submits that thereafter a show cause notice was issued to the petitioner in the matter, and an inquiry officer was appointed to hold an inquiry into the allegations now coming on record against the petitioner. He submits that the inquiry officer had held the inquiry following the principles of natural justice and affording all reasonable opportunity to the petitioner to defend his case. It is also submitted that the petitioner was allowed to cross-examine the witnesses deposing on behalf of the corporation during the inquiry. Also, he further submits that the inquiry report having been submitted by the inquiry officer and the same having brought on record the fact that the allegations leveled against the petitioner stood established. The managing director of the corporation, on consideration of the matter, proceeded wide order dated 22/12/2015 to remove the petitioner from his services as a trainee driver in the corporation. Dr. Chomoha further submits that the said course of action was taken so as to protect the interest of the corporation. Dr. Somoha further submits that the provisions of the Assam Services Discipline and Appeal Rules 1964, more particularly Rules 9 thereof, would not have an application insofar as the case of the petitioner herein is concerned, inasmuch as he was not a confirmed employee, permanent employee of the corporation, and was only a trainee driver. And accordingly, he submits that by following the spirit of the said rules of 1964, the proceeding against the petitioner was conducted, and he was, and on conclusion of the same, the allegations being found to have been established, he was imposed with the, he was removed from his services as a trainee driver. Mr. Somoha submits that the petitioner, having been granted an opportunity to have his say in the matter and an inquiry also being held, the principles of natural justice is to be deemed to have been complied with in the matter, and accordingly, the removal of the petitioner from his services or with the corporation would not mandate an interference from this court. Mr. Somoha, in addition to relying upon, in support of his submissions, has placed on record, the record has furnished to this court the records pertaining to the departmental proceedings instituted against the petitioner hearing. Also, I have heard the learned counsel for the parties and perused the materials available on record. The facts noticed herein above are not in dispute. The petitioner, the petitioner was removed from his services by the managing director of the corporation wide order dated 22/12/2015, which is projected to have been so issued, basing on a departmental, on an inquiry conducted in the matter pertaining to the allegation level against the petitioner of having misappropriated an amount of rupees 2,700, which was given to him as for meeting exigencies that may arise in course of the trip he was required to undertake to Gauhati, a reserve trip he was required to undertake to Gauhati on 23 5/2015. Also, the projections made by the learned counsel for the petitioner, for the respondent, is to the effect that the petitioner was issued with a show cause notice, and thereafter an inquiry was held in the matter, wherein the allegations leveled against the petitioner was established, and the same had led to the issuance of the impugned order dated 22/12/2015. Also, the said position was, however, disputed by the learned counsel for the petitioner, who had categorically submitted that there was no show cause issued to the petitioner, show cause served upon the petitioner at any point of time, and the inquiry that is now being projected to be the basis for imposition of the penalty of which is projected to be the basis for removing the petitioner from his services with the corporation, was in fact an inquiry which was held in connection to the suspension of the petitioner, which was effective wide order dated 23/6/2015. Also, having understood having noticed the submissions, the projections made by the learned counsel for the parties, this court has proceeded to examine, this court has perused the records produced in the furnished by the learned counsel for the standing counsel for the corporation. So this court finds that after the petitioner was placed under suspension, wide order dated 23/6/2015, he was required via a communication dated 8/10/2015 to appear before the senior divisional superintendent of the corporation at Gauhati for a personal hearing on 13/10/2015. The said personal hearing was projected to be in connection with the suspension of the petitioner effected on 23/6/2015. Also, the said hearing is found to have been conducted, and an inquiry report in this connection is also found in the records of the matter. A perusal of the said inquiry report, which was submitted by the senior divisional superintendent of the corporation on 13/10/2015, as the inquiry officer, would reveal that no evidence was found to have come on record with regard to commission of any irregularity by the petitioner herein. Further, the consumption of fuel by the said petitioner, by the vehicle in question, which had required which had led to the refueling of the same, which had led to the necessity of the refueling of the same by the petitioner, was also found to have been justified on account of the fact that the vehicle was required to move at a very minimum speed, and there was frequent change of gears on account of the traffic jam at Gauhati. It was also projected that the bus was required to carry out 4 local trips within the city of Gauhati during the period it was at Gauhati. Also, the said inquiry report does not in any manner, the said inquiry report in the considered view of this court, in addition to being not in pursuance to a departmental proceeding instituted against the petitioner, also does not bring on record any material to establish the charges, to hold a view that the charges leveled against the petitioner stood established. A perusal of the records has also revealed that on 8/6/2015, the station superintendent of the corporation at Gauhati, at Jorhat, had issued a show cause notice to the petitioner, wherein the allegation leveled against him pertained to the misappropriation of the advance amount of rupees 2,700 as given to him. Also, the further allegation is to the effect that the petitioner had submitted a false cash memo of refueling the vehicle in question for an amount of rupees 2,700. Also, while the said show cause notice is found to be available in the records, there is no material to demonstrate that the said show cause notice was actually served upon the petitioner hearing. A show cause notice which is available in the records, but not demonstrated to be served upon the delinquent, would be of no consequence in the eye of law, and the same cannot be projected to have the effect of instituting a departmental proceeding against the petitioner herein. The materials available on record only indicate to the effect that the hearing that was conducted that the personal hearing extended to the petitioner was in connection with his suspension or his order of suspension and not in pursuance to the said show cause notice dated 8/6/2015. Full stop. In view of the full stop, having drawn the set conclusions, this court would now examine the inquiry report and the consequential steps taken thereon by the respondent, by the authorities of the corporation. As noticed herein above, the inquiry report in no manner implicates the petitioner with the allegations leveled against him, and the same is only in connection with the order of suspension passed in his case. The pleadings brought on record by the respondent corporation reveals that the impugned order dated 22/12/2015 was so passed basing on the inquiry report as submitted in the matter by the inquiry officer. The inquiry report having not brought on record any material to hold the charges, the allegations leveled against the petitioner to have been established, it was permissible for the managing director of the corporation to pass an order or to impose a penalty and or remove the petitioner from his services only after a disagreement note in this connection was formulated and communicated to the petitioner herein. The materials brought on record, including the disclosures made from the records furnished by the learned standing counsel of the respondent corporation, does not reveal of any such disagreement note being prepared and furnished and forwarded to the petitioner herein prior to the issuance of the order dated 22/12/2015. So, accordingly, this court is of the considered view that the order dated 22/12/2015 has been so issued contrary to the materials available on record, and accordingly, the same would mandate an interference from this court. The order of the appellate authority only having noticed the steps taken by the authorities of the corporation leading to the issuance of the order dated 22/12/2015, the same would also mandate an interference from this court. Also, the Honorable Supreme Court, also, in view of the above conclusions reached by this court is of the considered, this court proceeds to interfere, set aside the order dated 22/12/2015 and the order dated 21/7/2015. The impugned orders having been interfered with, the petitioner, the respondent corporation, the respondent authorities are directed to reinstate the petitioner in his services forthwith. Also, having directed for reinstatement of the petitioner in his services, an issue would arise as to the back wages. The petitioner would now be required to be authorized. This court finds that the petitioner was, this court, in view of the conclusions reached herein above, finds that the petitioner was removed from his services without following a due process of law, and accordingly, the removal was held to be illegal, was interfered with. Accordingly, the petitioner, however, this court cannot lose sight of the fact also that the petitioner, after he was removed from his services, has not been discharging his duties in any manner with the respondent corporation. accordingly. Also, this court further by considering the fact that the present writ petition was pending before this court since the year 2017 and it not being and the remanding back the matter to the respondent authorities would further delay the reinstatement of the petitioner, directs that the petitioner be reinstated in his services and the period he had remained away from his duties after the issuance of the order dated 22/12/2015 be regularized notionally and the pay of the petitioner fixed on the date he resumes his services accordingly. The petitioner be paid back wages to the extent of 25% of the total back wages now he would be entitled on account after the notional computation of his pay and allowances is so made. The said directions, the petitioner be reinstated in his services forthwith on receipt of a certified copy of this order and the back wages to the extent as directed herein above be released to the petitioner within a period of 3 months from the date of receipt of a certified copy of this order. With the above observations and directions, the present writ petition stands disposed of. The records produced by the learned standing counsel of the corporation is handed over, is returned to the is returned in the court today. I have not gone for 100%.
Bless.
But still I have this doubt whether I should make it 50%. I'll think of it. But it will not go above 50%.
Bless.
Yeah. Mr. Chaudhary, why are you here?
I have an item
Which one?
on order. Item 36.
36. Yeah, the opposite party is here.
Not,
Compliance report was to be produced. Yes.
we have not received anything as yet.
Mr. Chaudhary, you need not wait. Can you ask your colleague to just call the respondent so that
Yes.
moment he comes, we can take up the matter?
Yes.
You can just ask him. Who is there?
Petitioner.
Mr. Kotoki is there. Just get hold of Mr. Kotoki so that we can take up on this matter. I don't want you to be waiting here for long. Oh.
This matter relates to reassessing of answer script for the year
For
2000.
me, it is permissible. Re-evaluation.
Reassessment, my lord.
Re-evaluation.
My lord, even for
Now tell me one thing. You have held that there are certain answers which has been held to be wrong.
not evaluated in.
No, forget the evaluation part. We will come to that. But there are some questions which you say are wrong, right?
According to the petitioner.
Petitioner. What is the basis? This court is not an educationist. What is the basis?
My lord, petitioner.
Say answer A.
Yes.
You wrote it in a particular manner. It was held to be wrong.
Yes.
Now, what is the material you have brought on record to show? No, this is the answer, HEMCO, or any document which is of value. Where is that?
My lord, petitioner in other subject.
Forget the other subjects. We are
For
concerned
our
with
satisfaction.
63 marks in.
My lord, for
She is an exceptionally brilliant girl.
yes, my lord. 98,
Exceptionally brilliant girl. I
97,
think
98.
she will do much better. And she may have done much better in her life now.
Yes.
But the thing is, when I have to adjudicate, I'll have to adjudicate on the basis of something. I cannot do it on basis of emotion.
Lordship ne send the matter to the expert body.
No.
My lord.
You show me. Which are the questions which were not evaluated?
My lord, in
Show
affidavit,
me from the answer script.
my lord, in affidavit, my lord, page 89 onwards. Page 91.
No, you have the answer script here.
Yes, my answer.
Show me from the answer script. Which question was not evaluated?
My lord, page 91, question number 16A.
No, no, show me from the answer script.
Page 9.
You have the answer script.
Yes, my lord.
Show me from the answer script.
My lord, page 56.
56. Okay. Yes.
Last 16. You
law.
Ponson, yes.
Oh,
Ponson audio, comma, Bobri, comma. That was not assessed. It should be corrected, my lord. It should be given marks. Then page 66.
16 kho.
Yes, my lord.
Okay.
Then page 66. Question number 4.
Easy.
Bata, Sobor, etc. Tom, Sangitam. Not evaluated.
This is Hindi.
My lord, actually in Assamese there are 2 parts. Group A consists of 75 marks. Out of 75, I secured 63.
Oh, C
Group
part.
C.
So group C is Hindi.
No, my lord, it is Sanskrit Rijuvarati.
But this is Hindi.
My lord, Sanskrit.
Sanskrit, okay.
Yes, out of 25, I have got 0. In group A, I have secured 63 out of 75. Out of 20.
So answer number 4 is not evaluated.
Yes, my lord. Then
And
6A, then page number 67. 6A 2, then 2, 3. 16.
16 A
Last.
2 3.
Yes, my lord.
Okay.
That apart, my lord, next. 92. This honorable directed to me. Page, my lord, then 69.
69. You give me the complete list.
I have given, my lord.
No, from here.
Yes, my lord. Page
69,
9.
which one?
69, 7 co.
7 4. That is cross.
My lord, according to me,
So where is the basis for that?
as per my
This-
knowledge, as per
I
my
can't
knowledge.
use that word which starts with
Yes.
Ga.
Yes,
I can't use that for me.
yes, my lord.
If I am that only in so far as this, how can I know this is correct?
66.
Then
Where is your material?
I have not collected the material,
Then-
but as per
Then
my,
you can't make such projections.
at least,
Till now, I've got it. How many? 1, 2, 3, 4 questions not evaluated.
not evaluated.
That we will ask Mr. But this correction part, I cannot.
Correction part 0 marks were given, but
Okay, what is the stand of the respondents in regard to the non-evaluation?
they have not stated anything. My lord. They have stated that
Yes,
not-
Mr. We are only with non-evaluation, nothing else.
Yes, my lord.
Yes, what do you say, Mr.?
Our affidavit, my lord, because, my lord, after examination result is over, my lord, from the date of commencement of the examination, within 4 months, we keep the, my lord, original.
But this matter is pending, so you might have kept the thing.
No, my lord.
Why?
This case is filed after 1 year. As per expiry of 4 months.
Okay.
We cannot keep it all the things similar whole year. The 3,42,000
So
something.
this
was kept.
petition was filed after 4 months.
After 4 months. That's why we did not keep it. That's why how can
Records
we?
are not there.
Yeah, not are there. If there is no original answer script, how can I will say, my lord? I will rely. How can it? After giving him a RTI, he goes to the, my lord, hands of the petitioner. He can do something.
Okay.
Well, in a similar circumstances, my lord, I have annexed the writ order, my lord, that writ petition has been tagged, my lord, on a same subject matter.
That division bench order.
Yes, my lord.
That is on a different thing.
That is
altogether.
different case,
There was a direction from this court not to destroy the papers.
My lord, they have already stated that the document has been destroyed, their submission, my lord. Even after destroying the disposal of the answer script, this honorable court directed to reconcile.
Where is that direction that it should be done on the basis of the photocopy?
My lord, only direction was there, but his statement was recorded.
There is a order passed by my Lord Justice Pahak in the matter, wherein he has said that don't destroy.
My lord, paragraph 19, initially matter was before this single bench, so notice was issued on Iman to the, if answer script of the answer.
Come to the earlier order, 19/1/2018. There is a categorical interim direction passed not to destroy and preserve it until further orders.
Yes.
My lord,
Mr.
even that, my
Sharma, we
lord,
also do some homework.
yes, my lord, even that, my lord, the paragraph has stated that the answer scripts were destroyed because as per SEBA regulation, answer scripts.
No, that is only with regard to that, but in that case, the thing was there.
Even
Maybe it was missed out. Where do you get it? Which paragraph?
paragraph 11, in my copy, actually.
Para 11.
12, initially.
Initially, matter notice in this one.
Last. Mr. Chutia submits that. Before the interim order, the answer scripts were
Okay.
destroyed.
Now tell me.
For satisfaction of the student, my lord, she is brilliant student out of,
That's the only reason why I am hearing this matter.
yes, my lord. You lodged a direct,
That's brilliant marks.
yes, my lord. 98, 97,
Unfortunate.
yes,
90, there is a 97 and she has
98.
got
also.
distinction marks.
Yes. Except
Young
Assamese.
girl.
Out of
What
25,
is she doing now?
present I don't have.
She might have progressed
Yes.
in life now.
But
4 years left. She's
if
doing
1
the
marks or
degree.
2 marks is increased, my lord, her career will be different, my lord.
Now it will not make any material difference, but other than the girl getting some satisfaction.
Somebody you
Here
lodge
got
direct the matter
already
to be
admission.
examined by an expert body.
What
my
are
lord.
the examiners doing, mister? This is the way they do it. Very sad.
For my set experiment, matter may be remanded to the expert body. On
You'll
the
not
basis of answer script, my lord, photocopy by answer script.
That is
You
the
have the
problem.
question paper?
Yes, my lord. Question paper, my lord, page 29 to 33, group A, and group C, page 25.
29.
36 to 38, group C.
Group A is
Group-
27.
Yes.
37. No?
29 to 33, group A, question paper. There are 3 groups, B or C.
Where is your mark sheet? You have
And
tabulated the marks somewhere. Yes, page 22.
page 22, in paragraph, my lord, I have stated, my lord.
Mr. Bhutia,
Page
My
6,
lord.
page 6, my lord. English 91, general mathematics 98.
no. Page 22 is the mark sheet.
Yes,
This is the original mark sheet.
yes. Photocopy of the marks.
Mr. Bhutia,
My
come to
lord.
page 22.
Yes, I have seen it.
63 marks,
Yes.
right?
Yes.
Now come to the answer script. Page 42.
Yes.
60.
60.
I calculate this, how much it comes?
Six-
10, 13, 14,
60.
17, 20, 21, 25, 26.
20 and 40. 17. 18, 19. It is.
What is this? If it is 60, how she was given 63?
Oh. It's 40. 0.
40. If it is 60, how she got 63? Casualness or something else.
No, my lord, extra marks is sometimes given
Where? How?
by the board.
How?
That is the, my lord,
How? Okay, the petitioner has not raised this issue. I am raising this issue.
you can remove board.
And Mr. Chutia,
My lord,
how did you evaluate the answer script, reevaluate in the other case? If it was
as per
destroyed?
guidelines, my lord, there is a guidelines.
No, if it is destroyed in the earlier division bench order,
Yes,
you said it was destroyed.
that's right, my lord.
Then how did you carry out the order of the court?
The division bench court. I don't know the result of the,
Get that.
that is the only one thing, my lord. They, in the division bench case, my lord, they challenge the regulation.
Forget it.
The
The
regulation
court did
court-
not go into that
Yes,
regulation.
regulation. There is a part of relaxation. There court direction is that if necessary, you can,
If necessary.
if necessary.
Otherwise, carry out the evaluation in the manner required.
That is the, my lord, that is the, my lord, direction. That being the position, we directed response number 2-3 to re-examine the unauthorized scheme of petition in respect of Hindi and general science.
Letter marks in all other subjects.
Yes, subjects of the ICC to 17 within the parameters of regulation
And the
48.
normal manner in which I could go through the answers. Brilliantly. Brilliant student.
While carrying out the same exercise, if it is felt that relaxation clause under regulation 51 or 50.
We are not concerned with the regulation. You carried out an examination. Now, you have carried out a re-evaluation of this papers, you say in your affidavit.
No, my lord, we have not said.
You have said.
We have.
You have said.
No, yes, we have re-examined it. We re-examined.
Why the misdoubt things were not taken into consideration?
So, my lord, the re-examination was done, and we find that there is no differences in the marks given by the original examiner. That's why it is taken.
Now explain this 63 and 60.
That is question 60 and 63, but that was when I don't know. Now I have noticed it.
You get your instructions on that.
Yes, sir.
And also how you made the evaluation in the other case.
Other cases with, we are not evaluating, not only re-checking.
There is a direction.
Direction is given. The earlier
How
case.
did you do that re-examination if you did not have the originals with you?
This, as per this court's order. I will obtain instruction.
Heard Mr. N. Sharma, learned counsel for the petition at some length. Mr. T.C. Shutia, learned standing counsel, appearing for the respondent board, submits that he be given a week's time to clarify as to how the petitioner was given 63 marks in her mark sheet, while in the answer script, the petitioner had scored only 60 marks. The learned counsel for the board shall also apprise this court as to how the evaluation in respect of the petitioner in WPC number 6226/2017, re-evaluation of the answer script of the petitioner in WPC number 6226/2017 was carried out in pursuance to the directions passed in this connection by a division bench of this court, while order dated 8/2/2018, when it was the stand of the board that the answer scripts in question were already destroyed. So, the said instructions be received by Mr. Chutia in writing from a competent authority of the court and placed before this court on the next date of listing. Registry to list this matter. How long will you take, Mr.
After 1 week, my lord.
Okay, fine. We'll have it in May, no problem. On 6th or 8th? 6th. Registry to list this matter again on 6/5/2026 for further hearing. Let us see, Mr.
Yes, obliged, my lord.
We can do something for the girl.
It is pardon, my lord.
Further hearing.
In this case, we have file affidavit, our affidavit in opposition.
My pleasure, Lordship.
1999 PGLP.
My pleasure, Lordship. They filed their affidavit, the Director of Secondary Education. In an affidavit, they has admitted everything, whatever is in the writ petition, Lordship. Lordship may come to page 51, para 5.
So you mean to say Mia Bibi Raji, what the Kaji will do?
That's. Then I have nothing to
If
say.
you have admitted, give it everything to him. You are appearing for?
School.
Give him.
He has admitted everything. Whatever in his petition.
Admit in the factual part, we have admitted that he rendered his service. But regarding the regulation or absorption, it cannot be permitted, Lordship. This is the problem.
Because he is an honorary appointment. Appointed him on regular basis.
The IS had issued an order in 2005, Lordship, giving him salary against a different post.
But he was a
Leave vacancy.
leave vacancy appointee, then honorary appointee, and you are still growing that scale.
No,
No.
What are you doing now?
no, he has not been paid since 2006, Lordship.
6.
And there was no termination order also regarding that. Because there was no GPF and all that. My salary was stopped after 31st.
Your GPF was also deducted.
No, there was no GPF because I was not regular.
Domboro Dor Kolita.
Lordship.
Honorary appointment in a provincial high school, division bench. How can I?
Lordship.
I've already dismissed matters.
Lordship. Regarding honorary appointment, there is a difference in two cases, Lordship. Let us discuss that Gogoi's judgment, Lordship Gogoi. Here, I have got this judgment also. Honorary appointment does not get a sanction post salary, Lordship. In every case.
That's a arrangement made illegally by the inspector. We cannot give an approval to that. The inspector had no business to do that. And that is the stand taken by the director. Rightly so.
Lordship. But thing is that regarding this matter,
you do one thing, you go to the civil court, file case against Mr. Day and take whatever you want to take.
Lordship,
Damages, compensation, whatever you want to take, we'll provide for that.
30 years, Lordship, my has been waste. And another case.
On the prayer of the learned counsel for the petitioner, register to list this matter again after 2 weeks on a date to be fixed by it. You try it somewhere else. I am dismissing it otherwise. You try. But if it comes back to me, I'll dismiss it. You try. Yes. I'm bound by my orders. Can't help it. I've dismissed matters. Today feeling bad
But
to dismiss.
regarding if they admit it, but if they wish to, then
Will not. See.
it is their discretion, government.
Okay. Now let us examine your matter.
Lordship.
You were appointed.
Lordship.
Dehaws any post? Dehaws any selection?
Lordship.
Latest decision of the Supreme Court, Modern Singh. Supreme Court said no regularization.
Lordship.
Now don't pressurize me to dismiss your petition. You try.
Lordship.
And you have an option against with Mr. Day. Catch hold of him nicely. That give me my money.
Lordship.
Yes. Done with.
Hello.
Done with. Anything left?
Hello.
What is left?
Hello. Still, punishment is with me. Punishment is for me.
Punishment is
1
gone
year
now.
punishment
That
is
has
for me.
become odious
So-
because you have got your mark sheets. You got everything. Why are you pursuing
No,
with
my lord,
this?
not mark sheet, but I have wasted 1 year for them. They have imposed
Go
a
and file
penalty.
a We'll give you liberty. Go file application for seeking compensation. Damages.
My lord, his past, that past certificate may not be in the record.
No, that's my lord. What the thing is that court can still examine
You give it to them.
whether the punishment was right or wrong.
We are not
But
going into that issue.
Because it is the anxiety of the person that I have been punished without anything. And this will remain even throughout my life that I have been
That
punished.
cannot be, my lord.
No,
That,
no,
That is washed out.
it will be throughout his life that he has wasted out one year. He has been penalized. And in everywhere, whenever you will apply for appointment, for employment, the question will be asked, why extra 1 year? Why extra 1 year? That extra 1 year will hunt him throughout entire his life. Throughout his life, that one extra year will hunt him. So let the committee, let
Okay.
they show.
Or the learned counsel for the parties at length. It is submitted that the pleadings in the matter is complete. accordingly admit the writ petition. Registry to list this matter for hearing in the month of July 2026.
My
Lord, please.
Anybody appearing for the principal?
principal.
The principal has forwarded the pencil papers.
Yes,
Huh?
yes,
It is with the director now.
yes.
Yes, director.
Lordship, I'm appearing for the director, Your Lordship, please. Lordship, as per my verbal instruction, Your Lordship, some documents with regard to respondent number 7, that is the principal, are yet to be furnished to us.
What documents?
Your Lordship, the service book and some other documents that.
Why the principal is not furnishing those documents?
Lordship, no, I'm not putting it on the bus also, Lordship, that she has communicated to us, the headmistress, that she is going to furnish it within this.
Why? Why the delay?
Lordship,
Why the delay? When did you retire?
31st July 2023.
Lordship,
Who is that lady?
the respondent number 7, Your Lordship.
Headmistress.
Lordship.
She is still in service.
Yes.
Why is the delay?
Lordship, the director, that is what.
The Learned Standing Council, PTC submits that although the pension proposal in respect of the requisite document, the pension papers of the petitioner was forwarded by the respondent number 7 to the director. Bodoland. Director?
Rural and Territorial Council, sir.
A Director of Education,
Education,
Bodoland Territorial Council. However, it is found that the documents are requisite, like the service book of the petitioner, then
That is what he told me, Lordship, about service
what?
book
And next what?
and other documents.
survey, like the service book of the petitioner has not been forwarded by the respondent number 7. What's up?
My lord, may kindly have a look at during the pendency, this communication was made, my lord. And if my lord takes the second page, an email. Here the reason is given for the return of the pension papers. So I guess service book has been provided. Here.
Now, what steps will you take?
My lord, the stand that is taken that I have received first ACPS. But the fact is that first ACPS, I did not take first ACPS. I directly got the.
Those are things which they have to resolve.
Yes.
If you have taken, let them deduct. But why keep it hanging?
Hanging.
So and so. On the next date of listing, the director, the director of school education, the director of school education,
Education.
BTC, shall take up the matter with the respondent number 7, that is the headmistress, Ian Himatsinga High School, and ensure that all requisite documents are submitted by the respondent number 7 within a week from were submitted on or before 6/5/2026 to the office of the director, BTC. Also, the director BTC shall also apprise this court as to why there was a delay on the part of the respondent number 7 in forwarding the documents requisite for preparation of a pension proposal in respect of the petitioner herein, although the petitioner had superannuated from his services on
31/7/2023.
31/7/2023. Also, the said instructions be furnished to this court through Mr. N.R. Sharma, Learned Standing Council, PTC, on the next date of listing. Registry to list this matter again on 11/5/2020. You're getting a provisional pension?
Yes, my lord.
For the respondent number 11.
Mr. B. Sharma and Mr. P. Soikia, Learned Councils, are present representing their respective respondents. Mr. Sharma,
Lordship.
take it seriously.
Absolutely.
Obliged, my lord.
Obliged, Lordship.
Or we will have the respondent number 7 here. This is not done.
My lord.
Obliged, my lord. My lord, may I pray after this call taken after some time also? Obliged.
Sometime first half itself.
Oh, obliged.
My lord, kindly have a look of the last order, my lord.
You have paid for?
Correspondent number 8, Lordship. And Mr. Kam is for 9. He's on legs before some other court, Lordship.
Yes. Who is appearing for the elementary education department? Wait for some time.
Lordship.
Today is a holiday, my lord. That is why my lord, I could not.
Call up your commissioner in his house. Why is he sitting over the matter from 2025?
I have tried to contact the legal consultant, my lord, but since today is holiday, my lord, that is why. So, my lord,
28/4/2025. What is he doing?
that information I could not collect, my lord.
Then
My lord,
we are asking him to be here.
day after tomorrow, my lord.
No. The man will lose his chance. Who will compensate?
And because since today is holiday, my lord, that is why.
We can't help it. You have been waiting from 28/4/25. A contempt petition is pending. Still no reaction. Why? Is this the way you are running?
Tomorrow, my lord. In that case, tomorrow, my lord.
The portal is open till tomorrow.
My lord, what I am being instructed is, my lord, if your lordship opens it up for me till tomorrow, my lord, or 2 days extra, what will happen is the admissions will get over tomorrow. So nowadays, what the students do, they themselves, it's there in the notification, they themselves apply, my lord, and we are simply to approve. So everything will be over. So I will only be benefited.
Students, he will not get students.
I will only be benefited if it's left open till the compartmental examinations which are coming up in May. Till then, if the benefit is given, ma'am.
Compartmental examinations will be from the students of your institution only. There cannot be outsiders coming and applying.
Well, the outsiders will apply.
And 25/26, that we are not permitting.
Well, there, the 24/25 were there, my lord.
24/25 are there. That
and what will
if
happen
there is any problem, we will do it. But this is for fresh advertising.
And again, my lord,
26
This is for fresh entry.
26/27, my lord. In fact, kindly page 46, the last man. The registration process for selection 26/27 is scheduled in the month of June 2026.
So since repeated inspections are going on, my clients have instructed me that tomorrow when the officials from the director's office or the department will come, they will say you have got the benefit from the court, still there are no students. Since so if you don't have any students, why do you need the permission? That is
You
also
don't have any students in 25/26 also.
but the 20
You had no admission in 25/26.
No, it's admitted, madam. No. But the first years of 24/25 were there. They did their second year in 25/26.
This is not for them. This is not for them.
This is for the fresh ones.
So this is for the fresh one. We will await that till tomorrow. We will await. We will await. Because 25/26 you had no grievance also.
Yes, and also I'd like to point out one small thing in the order, but not the very last line of the order. Since the relief being paid has already been granted by order dated so and so.
That is for 24/25.
Yes. But consequently, the impugned notification dated 1/4/24 stands set aside.
We are not.
1/4/24 said that non-permitted institutions are not allowed. So if that being set aside, it should have been
Now,
open.
today I open it for you till tomorrow. I open it. Students have already applied.
Yes.
So they will not be choosing your institution.
No.
Then what fun it will be there?
Only
Students have already applied for 5 institutions.
Yes.
You are not there, so you have not got a call.
No.
You have not got a selection.
No, my lord.
So even if we open it, it is of no consequence.
That's why my prayer is, my lord, since they are yet to comply, my prayer is till the componental examinations take place. There are a lot of students comes up.
These are admissions, first year.
I understand. I'm talking about.
These are first year
I'm
admissions.
talking about class 10th, man. Class 10th compartmental, madam.
Compartmental, how will, these are new admissions into the system. And these are higher secondary, not metric.
First year, my lord.
Mr. Bhardwaj, be very clear. This is this is for higher secondary, not for. You come to the page 45.
I have seen, my lord.
45 and in fact, the prayer is also, my lord.
HS first year, man.
So metric, where is the metric thing coming?
But what I have been said is that those students.
They cannot, because that will be in May.
Yes.
That will be in May.
Yes.
Those students, no college will be available because the portal will be closed
Again,
on 22.
But that is my submission.
If it opens again, we will open it for you. We'll open it for you. We are only requiring Mr. Khatonia to come up and tell us as to why that order of 28/4/25 of this court is not. Because if they have rejected your application, that is the end of the matter.
Yes, my lord.
And Mr. Roy perhaps can get that information whether it's going to take place in May and a separate notification comes up or not, because it's repeats.
Mr. Roy, you get that information for tomorrow.
Yes.
In that case, my lord,
Whether for compartmental, the portal would again be opened.
my lord, in that case,
The learned counsel for the parties. Considering the issue arising in the present writ petition, Mr. N.J. Khatonia, learned counsel for the petitioner, for the learned standing counsel, secondary education department, is granted time till
day after tomorrow, my lord.
आज की मैंने
21, my lord.
23/4/2026 to receive his instructions, to complete his instructions. Mr. Khatonia shall apprise this court on the next date or listing as to the steps taken by the departmental authorities after the directions were passed by this court wide order dated 28/4/2025 in WPC number 4906/2024. You just write down the other cases also, which is the order.
Yeah.
So, Mr. Bhardwaj has basically raised a grievance in the present writ petition that in the event the portal is closed, the students seeking admission into the HS first year course after the completion of the compartmental exams, the petitioner school would be deprived of having students selecting the school for the purpose. Also, the present exercise initiated by the notification dated 10/4/2026 is seen to be for fresh entrance into the HS first year course. Also, however, Mr. D.K. Roy, learned standing counsel, Assam State School Education Board, shall receive instructions as to the manner in which the board shall provide an avenue for the candidates who shall be successful in the ensuing compartmental examination of HSLC for admission into various schools offering higher secondary courses. Same order, same order.
Obliged.
They filed affidavit in this case at last, my lord. Or the issue involved in this case is, my lord.
Sir, not before you raise the issue. There is a latest decision of the Supreme Court, Madan Singh.
After this thing.
Those are now.
After Dharam Singh interview.
Everything gone. Now it is Madan Singh. Madan Singh says that if you are not appointed by way of a selection, against a regular post, you are not entitled to it.
Latest, my lord.
Latest, 3-4 days back.
We'll go through
Madan
it.
Singh,
We'll go through it.
just go.
We'll go through it, my lord. I'll
Just
make my submissions on that. Yes.
On the prayer of the Learned
Yes,
Council
yes.
for the petitioner, register it to list this matter again on 30/4/2026.
I'll go through
Just go through that.
Yes, obviously. The
It
Jaggu,
goes
Dharan,
back to Umadevi.
Umadevi it goes back to.
One time exercise, it will be till
By the
2006.
same bench, my lord, Justice Bikram Nath. No, different.
Different.
Because all those judgments came to the same bench.
That's it.
Dharam Singh,
This is-
Jaggu, Bhulanath.
2-3 judgments.
Yes.
contrary.
Yes.
Just go through that.
I'll go through it, my lord. This matter. Obliged.
Obliged, Lord.
As per direction of this honorable court, my lord, we have filed
Okay, fine.
additional
We have
affidavit.
got- we have got it. Yes.
Lordship, we may be allowed.
What will you bring on record?
Lordship, something, and the honorable court last
Now,
occasion.
you are Mr. Kayum. They have passed.
Because the school is no more beyond
You show me after this, what is left? Your certificate is fabricated, forged.
Lordship, that apart, Lordship, last occasion, the honorable.
Forget the last occasion. Today I am telling you. You show me what is there. Your certificate is forged. Latest Supreme Court decision, Vinod Kumar, that only on an application or verification from the very issuing authority, if they say that the certificate is false, end of the matter.
Basis of that certificate, Lordship, kindly 118 Annexure B, their report, Lordship.
118.
Let this affidavit.
My lord, today we have served the copy.
Lordship, they have served the copy, Lordship. Today so I want to file my reply.
Give me.
Yes,
give me.
ma'am.
You're still continuing in service.
No, Lordship. Everything, Lordship, will go, Lordship. Just 118 page, their report, Lordship. Point number 2, may I kindly.
Just a moment. Secondly, after verification of the rechecking results, it is found that only one candidate bearing number so-and-so was found successful, but the roll number of Lohit Fukon,
Is not recorded in the list of
rechecking result, fine. It's not there. It's not there. Can't help it. From where did you get that certificate then? Thirdly, when they verified the photocopy of so-and-so is verified, only one, they have said that in their affidavit.
Everything was informed to the school, Lordship. And
Forget
that
it.
apart, Lordship.
You
let them-
file case against the school.
Lordship, with that apart, Lordship, the last occasion record may kindly peruse, Lordship, the original record. Because, Lordship, but the roll number of so-and-so is not recorded in the list of rechecking result.
That is English. They say that there was no material to show that there was a rechecking done. You show me your application for rechecking. Show me the application you have submitted for rechecking.
That was submitted.
No, you have
to
not
the school,
that
Lordship.
anyway. You have not. It's not in the school, mister. It's submitted there. School just forwards it. If you have submitted in the school, it has not reached there. What is the significance of that?
Lordship, on that count, Lordship.
Then if you are so serious, what we do is that we'll hear you.
Lordship.
And we find that this is not there, we'll direct for a police investigation, filing of a criminal case against you.
Lordship, that may be, Lordship. I'm not on that, Lordship. Let me verify the things, Lordship. That
is to be verified.
Query on that, Lordship. The if application, Lordship, and I'll file a short affidavit, Lordship, within 1 week, Lordship.
No.
Or let me take instruction whether he has filed the application.
What instruction is required?
Lordship, please.
What is here to be
man,
instructed?
Lordship, got a job, Lordship, which was, Lordship, he lost, Lordship.
He got a job by forging documents. This court
Lordship,
can have no sympathy for it.
If, Lordship, he is to
unnecessarily.
Lordship, if the same has been for Lordship, the why he is to approach this honorable court, Lordship.
Oh,
So-
that we have reams and reams of case laws wherein forged document holders have come up before this court. Supreme Court also. So that is not a ground.
Lordship, there, my resolute submission, Lordship, I pray, Lordship, at least short date maybe, Lordship, I'll ask to clarify our Lordship.
Mr. D.K. Roy, Learned Counsel for the Learned Standing Council, ASSEB, has submitted that in terms of the directions passed by this court, an additional affidavit has been brought on record, has been filed today.
Yes, Madam.
Also, registry to list this, I've heard the Learned Counsel for the petition at some link. Do what likhi bade, huh? Registry to list this matter again on 5/5/2026 for further hearing.
That may be, Lordship, 7 or 8, Lordship, mail, because
Right.
I will be out of station for
7/5/2026 for
And
further
in the meantime, Lordship, I will file my reply on that, Lordship.
The petitioner is at liberty to file a rejoinder to the additional affidavit filed by the respondent both, if so advised, on or before 4/5/2026.
Much obliged, Lordship. If anything.
For further hearing, I have put it. We'll have it. Yes, madam. Huh? R. Akrit A. Jain, Learned Counsel, and Mr. D. Kayum, Learned, Miss A. Jain and Mr. D. Kayum, Learned Counsels, are present for their respective respondents.
Much obliged, Lordship.
Yes. Have you surrendered the PPO copy you have?
We have submitted all documents, ma'am.
Where?
Before the treasury officer along with our applications.
When?
In 2019 itself, my lord.
Mr. Chulia, where is that letter? Where is that you have brought it on record?
My lord, our application, my lord, page 21.
Where are the documents which you have submitted?
And PPO reference is also there, my lord.
Where?
In vernacular, my lord. Type copy also, my lord.
Photocopy. Original. Where is that original PPO?
Original, my lord, we do not have here, my lord. According
You might have it.
yes, and
Both your parents were,
Okay.
father, mother, both were receiving.
gosh,
So it is with you. Give it. Without that, they can't do. They will not be able to do.
they have instructed, my lord, that along with the application, all documents were
No,
submitted
where do I get it?
before the treasury officer.
No,
my
where
lord.
do I get it, mister? Just show me the documents that you have submitted. That will do. Where is that reference? Because if you come to page 27, clause number 6, photocopy.
Yeah.
Mr. Cholia,
Lordship.
please have a.
Yes, Lordship, if the petitioner can, or someone from the parent
They
can
may,
visit
they
the.
may not know also. What
Yes.
is required is a photocopy only.
Yes, Lordship. So
If that is there, Because both half, one half is kept with the
With bank.
treasury officer,
Yes,
another is with the pension holder.
yes.
So if it is there, ask him to.
Yes, I'll
immediately-
inform Lordship if the petitioner or someone
I'll
from the,
provide that.
they can just visit him. I'll inform the treasury officer.
In terms of the directions passed by this court, by the earlier orders,
Treasury officer, I mean.
comma, Miss K. Fukan, London, Government Advocate, has placed on record. K. Fukan, Leonard has placed on record an instruction received by her from the Director of Pension Assam. A perusal of the said instructions reveals that the pension proposal in respect of the petitioner hearing has been petitioners. Two. In respect of the petitioner's hearing have been received by the directorate. However, the further processing on the matter was not permissible on account of the non-availability of the original both halves of the PPO bearing number PPO oblique pension payment order bearing number PPO E/1189, and the treasury officer has been required to submit the both halves of the said PPO along with up-to-date payment certificate. Also, Mr. R. Ali, learned counsel for the petitioner, has submitted that the PPO in question, that the pensioner's copy of the PPO in question has been handed over to the treasury officer by the petitioners while they had submitted, along with their application submitted on 24/7/2019. Also, Mr. A. Chalia, learned standing counsel, Finance Department. You're a party?
Yes, Lordship, Finance Department is a party.
Respondent number 3. To receive instructions from the respondent number 3 as to whether both halves of the said PPO has been forwarded by him to the office of the Director of Pensions.
Yes.
Also, in the event the petitioners have not furnished to the treasury officer, to the jurisdictional treasury officer, the original copy of the PPO available with them, the petitioners shall, within a period of 7 days from today, approach the treasury officer, jurisdictional treasury officer, and submit the original copy of the PPO available with them. Also, the learned counsel for the respondents shall apprise this court with regard on the next date of listing with regard to the further developments taking place today after the passing of the present order. Also, register to list this matter again on 15/5/2026. You give it.
Lordship,
Mr. Cholia, you.
Lordship, I'll coordinate.
A copy of the instructions furnished by Ms. K. Fukan, learned government advocate, is kept on record and marked as X for the purpose of identification.
I'm praying for withdrawal of all items, Lordship.
Why?
Lordship, some of the petitioners have.
No, now I'm in item number 15. Why is Anjuma Tai Saikia want to withdraw the matter?
Item number 16, man.
16? Oh, sorry, Mintu Saikia. No, item number 15, sorry.
16, man.
15 hourly. Okay. Okay, 16.
17, Lordship.
16, Mintu Sharma. Why Mintu Sharma wants to withdraw?
All the petitioners are challenging one common speaking order.
Forget
by
that.
the Deputy Commissioner.
Forget that. I'm not concerned with others now. I'm concerned with Mintu Sharma. Why Mintu Sharma wants to withdraw? I'm imposing heavy cost now. You are taking this court for a ride. You had approached this court had dismissed the writ petition. You don't annex a copy. And you come up and rake up the same issue again. Tell me.
One speaking order was not challenged earlier, Lordship.
But you cannot have piecemeal challenges. There is a concept called constructive res judicata.
No, my lord.
You cannot.
My lord.
So
My lord,
now we will impose very heavy cost.
my lord,
Why did you advise them to file this writ petition? It is on your advice they have filed.
my lord,
Why?
a person to a order passed by the coordinate bench, Lordship.
Coordinate bench, that this order standing, you have a good number of years practice in this court. When an order passed by this court has attained its finality, how can any other development nullify that order? Now we will ask the petitioners to appear personally. We'll ask them why they have filed this. Who advised them? Why? This cannot be reckoned by this.
One petition on item number 30.
Why have you not annexed that copy of the order? You made a reference, but why the order copies were not annexed? Why?
I make apology, Lordship.
And you have not even highlighted that order before this court when the matters were taken up. Now tell me why you want to withdraw. Why? Took a chance.
Petitioner, item number 34, Lordship, petitioner has.
I am with item number 16. I am only in item number 16, Mintu Sharma.
My lord, yes.
What is the ground? Why did you institute this? And see, now while we're going further, you'll be in more trouble.
My lord.
In one case, you have gone up in appeal also dismissed. And thereafter, again, you have filed on the same issue, a fresh writ petition. This is a wrong advice. I'm sorry to say.
One speaking order was left out, my lord, we challenged. That speaking order was not challenged in the earlier writ petitions.
I think I'll have to pass a order imposing cost. And then only this thing will come to an end. Otherwise, tomorrow again, another writ petition will be filed.
Lordship also close the writ petitions, giving no liberty to file a fresh petition, Lordship.
How did you file this writ petition? Tell me that first.
One Anjalu Guru, Lordship, he has been now serving under the Governor of Assam, Lordship.
Yes, what to do?
One, my lord has correctly indicated because my lord that order has already passed. My lord.
Mr. Bhuya,
Some reflection in the order.
this is not expected from a council of district.
I'm sorry, my lord, I'm sorry.
This is not expected.
My lord, one last.
And you are not a junior one. You have enough years of service and you are a very competent lawyer. I did not expect this sort of petitions from you.
I realize, my lord. I really do realize, my lord.
Hope you realize and I don't get another thing
I will not come, Lord.
in this like from you.
My lord, I will try to come with good cases, Lordship. This time, Lord,
Please, this court maintain that dignity. That much only we are asking. If you have a cause of action, emphatically argue, but not in this surreptitious manner. I'm sorry, I'm using bad words. But Mr. D. Bhuya, Learned Counsel for the petitioner. Also heard Mr. B. P. Saikia. Also heard Mr. P. Saikia, Learned Government Advocate, appearing for the respondents number, Government Advocate, and Mr. B. Talukda, Learned Standing Counsel, Elementary Education. The petition, by way of instituting the present writ petition, has prayed for a direction upon the respondent authorities for consideration of his case for appointment on compassionate grounds. The father of the petitioner had died in harness on 25/3/2011. The petitioner had approached this court earlier by way of instituting a writ petition being WPC number 3720/2023. The said writ petition was given a final, was on consideration dismissed by this court wide order dated 6/1/2024. The said order, in absence of a challenge, has attained its finality. It is in the above background that the present writ petition has been again instituted, praying for the same reliefs as prayed for in WPC number 3720/2023. Full stop. What is a full stop? The said aspect of the matter coming on record, being pointed out to the learned counsel for the petitioner. The learned counsel for the petitioner has submitted that the same present writ petition has been inadvertently filed, and accordingly prays that he be permitted to withdraw the present writ petition. Also, the prayer is not objected to by the learned counsel for the respondents. Also, accordingly, in view of the submissions made by the learned counsel for the petitioner, the present writ petition stands dismissed for withdrawal. It is made clear that no liberty has been granted to the petitioner to institute any fresh proceedings, praying for appointment, consideration of his case for appointment on compassionate grounds.
I'm praying for similar order in respect of proceed, item
17
number
also same, Milord.
17, 33, 34. and
17 not WPC, data code.
487923.
33,
25, 124.
This audacity is too much.
For writ petition and it's same.
These are poor people, otherwise I would have imposed very high cost here. They have already destroyed their lives. WPC 1965/2025, disposed of 18/9/2020. Huh? Right? Our date of death of the father 17/7/2016. Item number 33. WPC 6240/2023. Dismissed 5/1/2024. Date of death 6/7/1991. Before. And here again, appeal before the High Court, division bench also dismissed. It shows you very in bad light. Please don't resort to such practices, sir. You're a young man, long way to go. Lekha, way to hold. WPC 7257/2023. Dismissed on 15/12/2023. The appeal preferred by the petitioner, being writ appeal number 184/2024, was also dismissed as withdrawn, wide order dated 12/8/2024 by a division bench of. Date of death 1/6/2002. So dismissed. Baki so vacated, no? Next time I get such things, Mr. Bhuya, what has been restrained today will come out on that day. Be very careful. Mr. Chaudhary, he has come. Oh, you are there. Mr. Kotoki.
I am already.
University. No, that
Yes,
Mr. Chaudhary is
contempt matter. Contempt matter.
Contempt matter.
Yes, I am for the principal and the GB, my lord. GB person.
So
Respondent.
who is to give the report now?
Yes, my lord, principal. In fact, a committee was constituted and the committee did not recommend the case of the petitioner, my lord. And I have already apprised my respected senior, my lord. I'll file an affidavit, my lord, so that he can also respond to that. Itu dia sih, last thought dia. Itu dia.
You are appearing for respondent number 1 and 2, both.
I think one.
Yes. 1 and 2.
They have done their part, my lord. Principal alone cannot do, also president cannot do. Committee is there, committee.
Mr. B. Goswami, learned counsel, appearing for the respondents. But Mr. Chi Chaudhary, learned senior counsel, assisted by
Sharma.
assisted by Mr. H. Sharma, learned counsel for the petitioners. Mr. B. Goswami, learned counsel representing the respondents, has placed on record the minutes of the selection committee, screening cum evaluation committee constituted for consideration of the case of the petitioner hearing for promotion from stage 2 bracketed senior scale to stage 3 bracketed selection grade. Also, the said committee on consideration of the case of the petitioner has found that the petitioner is not eligible for being recommended for promotion from level 2 to level 3. Also, Mr. Goswami submits that he would bring the said material, said resolution of the selection committee by way of filing an affidavit. The affidavit be filed on or before. When, Mr. Cho? Week's time?
My lord.
Week's time?
Weeks, my lord.
20 on or before 5/5/2026. Registry to list this matter again on 11/5/2010.
A copy may be supplied to me also.
He'll give you, he'll enclose that in the affidavit. He'll enclose that in the affidavit.
I also have to make an affidavit because.
That is why, that is why.
You can give him unofficially.
Yes, yes. I can give it.
He'll bring this on record by way of filing an affidavit.
Obliged.
You can take this back.
Yes.
Mr. Chaudhary can leave now. Mr. Chaudhary can leave now.
My lord. All right.
Lordship, in this matter, received my instruction, I'll be filing my affidavit.
Mr. A. Fukan, Learned, Standing Counsel, Elementary Education Department submits that the instructions in the matter has been received and an affidavit will be filed on or before.
2 weeks, 2 weeks, man. 2 petitions.
On or before 8/5/2026. Registry to list this matter again on 15/5/2026.
Deeply obliged.
Same lordship.
Same order.
Same order.
Next to same order. Connect
It's with common order.
common order.
Master.
Yes, pro rata pension.
Yes, Lordship, I have received the instruction yesterday, Lordship. So I'll file.
None appears for the petition on cop. Mr.
A.R.
Tabilda, A.R. Tabilda, Learned Counsel for the Learned Standing Counsel, Higher Education Department submits that the instructions in the matter has been received and he would file an affidavit in the matter on or before 11/5/2026. Also, you want to file? Accordingly, registry to list this matter again on 20/5/20. The respondent, the Mr. Tabilda shall ensure that the affidavit on behalf of the respondents represented by him is brought on record before the next date of the
Lords. Obliged.
May I, may I please, your lordship? The pleading has been exchanged, my lord. And the issue is very confined, my lord. They are claiming in their affidavit that I do not meet the criteria of the minimum number of, my lord, candidate appearing in the examination.
Come straight to 317.
My lord. One. 17 or
317, page 110.
My lord, my lord. For provincialization of services of teachers, services of one teacher or tutor as the case may be in each subjects, including the core subject in case of Venture High School or Venture High Madrasa or Venture Higher Secondary School or the Venture Senior Secondary School, at least 10 students must have appeared in the last final examination in that particular subject from that institution. Absolutely, my lord. And I am teaching mathematics and my records, my lord, the college records as well as my lord.
So, where is your record to that effect?
Yes, yes, my lord. My lord may kindly take up my reply rejoinder affidavit, my lord. Annexure 2 as well as, my lord, Annexure 3 reflects the same, my lord. And my lord may be pleased to find in the continuous pagination, my lord, it page 120 it starts, my lord. These are the admit cards, my lord, which this candidate appeared in the mathematics subject, my lord. If my lord may be pleased to find the subjects, English, mass communication, Arabic, logics and philosophy.
Yes, Mr.
My lord.
We have a report received from the, my lord, board, my
You
lord.
say the report is not before us.
Actually, my lord, that was not annexed in the affidavit, but report I have, my lord. Year 2016. I have marked it, my lord. Oh, only 8 students were appeared, my lord.
2016.
So this act came in 2017.
17.
So 16, you won that.
Yes.
Last 3 years, my lord.
No, it's not there. Last 3 years.
Yes,
Only
yes.
last year examination.
Last year.
Last year examination.
10 student must have appeared in the last final examination.
Last final
in
exam.
that
Last is
particular- my lord.
2016.
My lord. And we have, my lord, may kindly turn to page 156, my lord.
156.
My lord, of my affidavit, my lord. These are the, my lord, details of the candidate. 19 numbers of students, my lord, appeared, my lord.
No, the students have appeared.
Yes, my lord, it is.
Whether they are having mathematics as a subject, my lord.
Mathematics.
Yes,
That's the issue, my lord.
it is here.
Having mathematics as a subject.
My lord,
Yes, my
my
lord.
lord. And
But your
my lord, in the mark sheets also we have annexed, my lord, issued by this, my lord, council, my
16,
lord.
16. Where is that mark sheet of 16?
My lord.
Ah,
My lord, page number 120 it onward, my lord.
50 on 51 onward.
My lord,
28
my lord.
onward. Okay, okay, okay.
Of 2016, my lord. এইটো কি বস্তু আনিছে আপুনি যিটো দিছে
April কাটি দিম, মই দিম আপোনাক।
কপি এটা আছে যদি দি দিব।
নাই, মই এইমাত্ৰ হেল্প লৈছো।
They are having maths.
My lord, my lord.
Ooh. Yes, Mr.
Whether they are regular or not, that has.
That is the different thing, but you say from the school it has to be appearing. They have appeared from
My lord.
the school is
Yes, from
junior college.
From the mark sheet, it appears that all are having mathematics.
What
But
more
from,
is
from our report from the board, it is.
report? I don't know how this report has been prepared.
So, but better, I think, my lord, on this issue, whether they have appeared or not, I should have an instruction, my lord.
The heard Mr. Air Mojum Air Learned Counsel for the petitioner. Also heard Mr. N.J. Khatonia, Learned Standing Counsel, Secondary Education Department. The grievance of the petitioner in the present petition is to the effect that his case for provincialization was rejected, that his case for provincialization was not considered, and he was excluded from the purview of the provincialization exercise carried out in respect of the eligible teachers of HAM Girls Senior Secondary School on the ground that in the subject of mathematics, taught by the petitioner in the school for the year 2016, less than 10 candidates had appeared in the HSLC examinations 2016 from the said school. The petitioner in the reply, in the rejoinder affidavit filed in the matter, has brought on record the mark sheets of the students appearing with the subject mathematics in the HSLC examinations, Higher Secondary Final Examination 2016. What higher secondary final exam? So, it is seen that it is projected that more than 10 candidates, then students had appeared in the said examination with the subject mathematics from the said school during the year, during the year 2016. Also, accordingly, the petitioner submits that the petitioner fulfills the eligibility criteria for having his case considered for provincialization of his services under the provisions of the Act of 2017. Also, in view of the above, Mr. N.J. Khatonia, Learned Counsel for the Learned Standing Counsel, Secondary Education Department, prays that he be granted time till 2 weeks, man. Time till 5/5/2026 to complete his instructions in the registry to list this matter again on 6/6/2026. Keep this on.
Yes.
Yes, what is your instruction here?
Instruction is not so clear, but the one thing which I can not at least one thing which your lordship can make out from the instruction, Miller.
I'll have to make out now.
No, my lord, I'll make my submissions on that, Miller. But the petitioner has questioned the eligibility of that Zakir Hussain, Miller, who happens to be an assistant teacher, Miller, and his case is that Zakir Hussain is teaching social science, and he claims to be a teacher of SMEs, Miller. Now, my lord, the other two teachers, the one Azharuddin Ansari, my lord, who the petitioner claims to be the junior, but he is an Hindi teacher, my lord. Now, my lord, the qualification, if your lordship,
be very careful.
My lord,
be very careful in your submissions.
My lord, I'm making
it may have ramifications in other matters. Yes.
It's because
so one Assamese teacher provincialized.
No.
One Hindi teacher provincialized.
Hindi teachers is provincialized.
Assamese, there is language Hindi.
Language Hindi. Language Hindi.
Social science.
Social science is provincialized.
And science.
And science.
And he claims that he
is an Assamese teacher.
So if he is an Assamese teacher, whether he is senior,
he is otherwise in terms of his date of joining, he is senior.
Then why the respondent number, the private respondent was given?
No, that's he was the only Hindi teacher in this set.
Hindi teacher, if you take that stand, that when there is a Hindi teacher, the other language teachers will not provincialize. Take that stand, I'll record it.
No, Malad, that's what I've submitted, Malad. That by this instruction.
In that case, you say Hindi, Assamese, Arabic, all same. Senior will get. And now you come up and take an argument that no, because there is a Hindi teacher, he may be junior. Hindi is our language, national language, so we'll have to provincialize it. That is your stand supported by the Act. Show me.
No, the Act is silent about that, my lord. The Act
Then how
says,
can you?
Act neither even says
Can
senior,
your
my lord.
Director have the stance different
The,
in different.
my lord, in fact, the Act doesn't say about the seniority as well.
It says about that is a determination which is a reasonable
Determination from the service
criteria
duration.
which can be applied.
Yes.
Now tell
Now,
me,
my lord, that's what I said, my lord, this instruction which I've received, that is not clear on the point that why District Scrutiny Committee has not recommended the petitioner, my lord. Now, the teacher, my lord, who has been recommended, one is a Hindi teacher and then the other is an assistant teacher who is a social science teacher. Now, the social science teacher, my lord, the assistant teacher, he apparently is a senior to the petitioner.
what is the name of the petitioner?
Petitioner is Jahanara. Now, he is aggrieved by appointment of the provincialization of two. This is respond number 8 and 9.
He is Asmis.
My lord?
He is
Yes,
Asmis.
I am
He
Asmis.
is Asmis. He claims to be an Asmis. Now, respond number 8, my lord, Azharuddin, he is a Hindi teacher.
And he joined on.
He joined on 2009.
And she is working from 2003.
2003.
Oh, show me.
And my lord, respond number 9, he is of 97. So he will, there will be no claim against respond number 9 first.
Who is appearing for Azharuddin Ansari? Yes. How were your services provincialized?
As Hindi teacher, we are definitely.
Show me the law that Hindi teacher will get precedence over other language teachers.
Kindly say. Opposition.
Hmm.
With the application lordship.
Where is that?
Is 86 lordship. Much prior to 2017 election.
So that will have got no application here. We have an act. Why should we go into a notification?
Subsequent 17 lordship. There is also one notification lordship.
Where?
It's full accounting. 2019 lordship.
Where?
That is a letter lordship.
Where?
It is
83.
83 lordship.
80.
It is 83. It is 83 here in the Assam Education Provincial Services of Teachers and Reorganization of this Act 2017 under the provision of clause 311.
This is just a communication. This is not a decision.
That's what we
This is neither here nor there.
This is a national language, so Hindi is compulsory.
That is not the position of the act.
And lordship, more importantly, all the students have Hindi lordship. All the students of this school.
Maybe.
That is why
We
he was
can't help
inducted.
it. We can't help it.
That is why he was
We can't
inducted.
help
And
it.
from the
Then why was an Asmis teacher continued in this school? Should have asked her to go.
lordship, may I go to page number 108 lordship?
Mr. Why the respond number 8 was preferred, not you?
My lord, that is the reason behind, my lord, why they have been.
Your name was not forwarded. to
My
the
lord, my
DSC.
name is forwarded behind the DSC, my lord, but DSC not recommended, my lord.
Both the DSC and SC,
The essay did not reach.
yes.
So forget that. Tell me how. Even if the whole page 83, that is just a recommendation.
Page 83.
It
Page
says-
83 is a
Mr.
communication between the
Kaushik,
Malad.
Page 83 says that it is your understanding also that the Hindi is not given a preference. So you say that it should be given a preference while appointing Hindi is a national language. So till a decision in that direction is taken and the act is amended, that cannot be applied. So we'll interfere.
If your lordship will kindly say, my lord, the claim of the petitioner that he is an Assamese teacher, but his appointment was as an assistant teacher, not as an Assamese teacher.
Where is that? That is data?
Yes,
My lord.
yes, my lord. Let me show the dials data also, my lord.
Okay, forget it.
Even
This
the
is the particulars of stuff.
Yes, my lord, particular to stuff, my lord, that
Therein she said is set that as miss. Now, how will you take a different plea?
is 32.
32, 33, these are the particulars submitted. Okay, where is that dials data? Where is your name in the dials data?
Yes, my lord.
dials data starts from page 34.
Language, 37 language.
All are language.
All
Don't
are,
be an interfere.
all teachers are language.
Forget it, she is senior.
Even,
Okay, Mr. Kaushik, then what we do is, she will be appointed against the post of social science or science in accordance with her seniority.
no,
Because
so-
all teachers are all subjects.
no, then the
All teachers are all subjects.
then the social science, my lord, the respondent number 9 is senior to her.
Then he
1997.
will remain.
And the
He will remain. The next one, whoever is there will go.
that is respondent number 8.
Will go. Finished. What more is here? Simple. You submit.
And it is page number 109, Lordship, the final recommendation of the district level. Herein, Nasiruddin, the headmaster, was teaching English and social studies. Zakir Hussain, the respondent number 9, Lordship.
109.
Yes, Lordship, 109. Annexa 11, Lordship. Annexa 11. This is the final recommendation on the basis of which the services were provincialized, Lordship.
Nasiruddin.
Yes, Lordship. Nasiruddin is the headmaster, Lordship.
Hmm.
Who was teaching as per the recommendation here, English and social studies. Zakir Hussain, SS and SMS. So, wherein these subjects are social studies, come SMS.
Hmm.
And now,
Mr. Counsel,
Lordship,
once you make this submission, I'll not let you to retract.
Lordship, I
Go
am
ahead.
concerned with my subject.
Okay, go
and
ahead. Okay, go ahead. So this is the recommendation which has to be maintained, right?
this was recommended.
And this was accepted.
So this is not the actual position. Then
Mr. Counsel,
social
Mr.
studies.
Counsel, this recommendation is the recommendation that has to be upheld. That's what you're trying to say?
I am saying that in respect of others, what the court is doing, I have nothing to do.
Nothing to do. But this
But
recommendation.
I am trying to defend my appointment, Lordship.
Okay, fine, we got it. Lakha. You come to the Jahanara Begum, SMS and social studies.
Yes.
So then she will be above you. You are Zakir Hussain, you are Zakir Hussain.
No,
you are Zakir. She'll be above Zakir Hussain. Zakir Hussain will go.
Zakir Hussain is senior.
Zakir Hussain, 97.
Senior, 97.
Okay. You are?
Azharuddin
Which one? Where is your, what is your name?
Azharuddin.
Azharuddin. Hindi. You will go. After the, we'll say, you will come in. Because she is of 2003. She has social studies. And if we hold that Nasiruddin is social studies, Zakir Hussain will not come in because language will be, Zakir Hussain would be.
Is headmaster.
He's the headmaster.
Nasir.
And the enrollment is 150. So that
one
demands
headmaster
one
had come in.
headmaster.
So there'll be 3. So who has come in now? Zakir Hussain?
Between Zakir Hussain and Jahanara.
No. Zakir Hussain, then Ansari.
Ansari.
Then the third one?
No, my lord, if it Lordship sees like this, my lord, Zakir Hussain was recommended as social science and SMS.
No, who is the headmaster?
Headmaster is Nasir.
Nasir. Okay.
Now, if your Lordship sees like this, headmaster Nasir, my lord.
Let us see. Whoever recommended? Ansari.
Azharuddin Ansari.
Then?
Serial number 1, Nasiruddin recommended.
HM.
Zakir Hussain recommended as social science stroke
See
SMS.
the subject recommended, don't worry.
Bharat Chandra Das, my lord, science teacher. Ayesha Siddiq Begum, Arabic recommended. Azharuddin Ansari, Hindi recommended. Iqbal Hussain, SMS social science not recommended. Same like the petitioner.
Okay, now.
Jahanara
see
Begum.
here, 97, 99, 95. Only Azharuddin
Azhar
2009.
2009.
And he is teaching Hindi,
Hindi.
teaching Hindi.
right?
Right.
Show me. There can be 2 language teachers.
No, my lord, the act says languages.
Languages means 1 language, not languages. Mr. Kaushik, if you want to take that plea, take that plea. That for every language teacher, there will be 1. I'll be more
my lord.
than happy.
If your lordship sees the petitioner as well as the other one,
We'll
respond
have
number
that.
9.
We'll have it as 2. And be very careful.
Yes.
If you say languages,
Because
more than 1.
that determination, my lord, that determination whether the petitioner is a language teacher, that is not there, my lord.
That is already there.
No, it's they were both were.
This is a perfunctory exercise carried by you. We'll come to that. Yes. Mr. Kaushik, where do I get the list of the teachers who have been now provincialized?
That list, my lord. Page 109. No? Now, lordship will kindly come to page 107 for a moment. This is again the particulars, my lord, by the headmaster.
How many teachers were provincialized? Headmaster plus?
Headmaster plus
4, my lord.
4.
4. So, they are here.
All not here.
Where do I get it in one?
44, my lord, 42, my lord, page 42 of the petition, my lord. From serial number 137 to 141, my lord.
So, Nasiruddin is the headmaster.
Yes, my lord.
Zakir Hussain?
Zakir Hussain is the social.
No, there was some that list wherein the particulars were there.
Particulars, my lord, page 32, my lord.
32. Okay.
There are 2 particulars, my lord, different.
You tell me which one we should follow.
The one, my lord, both are, my lord, the headmaster, my lord. Now,
which one which we should follow? Wherein the dates are given, everything is given. Where do I get that?
Page 107.
107.
Yes.
Okay. The name of the petitioner is also here.
Yes, it is there.
Okay.
It is the particulars and by the.
So, Nasiruddin went as headmaster. So
went
no
as headmaster. Yes.
Zakir Hussain?
Zakir Hussain, he was recommended for subject taught both social science and Assamese.
Jahanara Begum?
Jahanara Begum,
Assamese and
Assamese and social.
Assamese and social. Okay. Then who was now regularized? Zakir Hussain.
Nasiruddin, Zakir Hussain, Bharat Chandra Das, Aisha Siddiqui Begum, and Azharuddin Ansari.
So who are junior to the petitioner here?
Azharuddin Ansari.
Only Azharuddin Ansari.
Only Azharuddin Ansari.
So Zakir Hussain, we hold it that he was there as Assamese or social science. Social science. Bharat Chandra, no dispute. Aisha Siddiqui, he has come, say, in the 4th post, which was additional post grade. Now it is between Azharuddin and Jahanara.
Yes.
Right?
Yes.
So Azharuddin can be regularized only as a language teacher. Because there is no post called Hindi teacher. It's language.
Language.
So it is Azharuddin and Jahanara between.
Hmm.
Now, if we see that, if they both are as language, then petitioner gets it.
But
what is the problem?
If the enrollment is similar, that enrollment was 150. So there comes
that lady would come in, Aisha Siddiqui Begum
there would be
come in.
two additional teachers. There will be two additional teachers.
Give him also. But how can you deny the petitioner from that day?
But if Zakir Hussain is taken as my lord social science,
that we cannot, we will not. Then Azharuddin will never come in. Because this lady, Aisha Siddiqui, was not there as a language teacher. Normal, that she came in the fourth post. So Nasiruddin will be headmaster. Zakir will be social studies.
in fact, my lord,
there is no dispute.
No, in fact, my lord, the professional qualification that at page 107, against the column name of the subject taught, the headmaster himself also has shown him as English and Assamese.
Forget it, but he is out of the purview of the teacher. He's a headmaster now. So he'll not be a teacher.
No, but he has been provincialized as a tutor.
But he is a headmaster tutor, HM tutor.
No,
HM
yes,
tutor.
no.
Yes. He is saying, where do I get it?
My lord, the provincialization list.
No, specifically mentioned, my
No,
lord.
it is tutor, my lord. Not a
headmaster tutor, not only tutor.
Only tutor.
So who is the headmaster then?
Headmaster is
There is no
Nasiruddin.
Nasiruddin.
Yes.
No, there is
That's
no
the
such
position.
head.
That
He
is
is
a
getting
different-
as tutor headmaster.
He is headmaster, my lord.
No.
There is no concept of headmaster. How many teachers who have been professionalized?
The headmaster would come, my lord, only after when the merger of the base school is.
So you say that he has gone as the language teacher.
Language.
Then Zakir Hussain, social studies.
My lord.
Right? Then Bharat Chandra does maths. Done with?
Done.
Huh? Then there are 2 posts now left. Additional posts. Right?
Yes.
Then how come Azharuddin comes in?
The additional teacher as a Hindi.
Where is that law? Show me.
No, there has to be one additional teacher.
One
Now-
additional teacher, it will be either him or the Ansari.
Well, that
now
is
show
also
me
not-
how
that is also not-
Ansari, by way of a Hindi teacher, he comes in.
No, because now
Just show me the provision of law.
no, the provision of
It cannot be at your ifs and dissent that one case you say
Absolutely.
this,
Absolutely
other
not,
case
my
you
lord.
will say that.
Now, if your lordship will kindly see the requirement in the law in the 2017 Act, it simply says, my lord, in case of
RT Act.
yes, additional recharge in case of RT Act.
So additional would be Aisha, Azharuddin, 2 posts. Right? So there is no post of headmaster. Let us say there is no post of headmaster. So 150, you have given them 5 posts minus headmaster. That means 1, 2, 3, 4, 5. Azharuddin comes in the 5th post. Right? He cannot. He is junior to the petitioner. Now that will have to be on the basis of seniority. It cannot be. Because the rule says 3. You have done it. 4th one post will have to go to him. Or the 5th post will have to go to him. We'll construe it to be 5 posts. And we will construe that Nasiruddin is a tutor, not a...
No, Nasiruddin has been provincialized as a tutor.
Fine, he'll be tutor.
So the section
So
7 and
5
8,
people- total
there's
5
a
people have been-
two classes, my lord, one teacher and the tutor.
There would be 5 persons provincialized. Forget the tutor-teacher concept. 5 have been provincialized. 3 in terms of the provisions of 311 or 390.
311. 3111.
2 because it is 150. Right? Now the 3 gone. 2 posts. Aisha Siddiqui, she is some din. She has come in because of her seniority. The next would be the petitioner, not the...
The Act is not so specific on that point.
We'll
yes.
specify.
Yes. But otherwise, my lord, if the
Otherwise, how will you do it? You cannot do it.
If the
Or you tell me
if the
that for
identification that
each
is
subject of language, you have to have a teacher, which you tried to argue. I stopped you. You argue that. I'll record that. It will be beneficial to all.
well, the act simply says, well, it has to be one teacher for science and mathematics, social studies, and languages. Now, the given a situation, well, it is before the district scrutiny committee.
Forget your district scrutiny committee.
Well, it's the district scrutiny committee because
go by the materials available on record.
Well, that materials that is available on record does not even determine him to be an assistant SMS teacher only. The only SMS teacher.
Mr. What are the documents here? Is the documents are same for all.
Yes.
And he has come in only as a Hindi teacher. By virtue of his Hindi teacher, which cannot be. And that too in a post, not outside that 3. Anything more?
Because he is one of the additional teacher's post has to be seen on the date of when his appointment was done, whether there was a requirement of an additional teacher or not. Now, if that is done, now the Hindi teacher, he was appointed in 2003. Now, based on the enrollment.
We cannot go into that. Mr. Kaushik, please don't try to take this court to places which this court need not go.
No, it's my.
It's not your endeavor. That's not the correct endeavor, Mr.
No, what I'm trying to say is, additional teacher, in fact, as per the RT Act, would be when the enrollment is above 35. Now, these 2 teachers, the Arabic and the Hindi teachers.
How you got in Aisha and Azharuddin? Tell me the basis for their inclusion. Because they are beyond that 3.
That is what district scrutiny committee's recommendation, to kindly say. Is 10?
Page
109.
Page
110.
Sorry,
39 in my requisition.
Page 39.
It's 109, page 39. No, page 39, sorry.
No.
This is
This is the most bogus one. No specification.
No. 39 and 109 is same.
Same. So we'll have 39.
Yes.
Now, if you see 39, 1, 2, 3, 4, 5 recommended.
5
What is the basis for that recommendation?
Now
Nothing.
This
Nothing. Just said recommended. How? What are the parameters considered?
the minutes is not there, It is the
page 39.
Page 39. The prior page there has to be a minutes,
Where is the minutes?
Minutes, it's not on record.
Have you brought the minutes on record?
No.
The commissioner and secretary says DSC has not given. He is that powerless. DSC has not given.
To that extent, I understand. The appellate authorities that order.
He's an appellate authority.
Yes, appellate authority's order is not
the way he passes an appellate order.
That's
unfortunate.
That order is unreasonable. That I accept.
Okay, we have understood. We'll pass the orders. We are interfering with the appointment of you are for Azharuddin Ansar. We are interfering with your appointment.
Worship, my submission. Worship, the school from the very beginning has Hindi subject in terms of the 2000.
We are not concerned. We are not concerned. You are not coming as a language teacher. There is no provision in the rules that a Hindi teacher has to be appointed. Show me the law. Show me the law. That much only. Your understanding will not work here. Show me the law.
As Mr. Kaushik has said, in case of minimum 3 teachers, language, so far my understanding is concerned, Lordship, subject to correction. That 1 language teacher, 1 science teacher, and 1 for art subject, other social studies or something like this.
Other than if there is additional teachers required, there is no provision.
In case of,
it will be the discretion of the director or the DSC or the SLC.
In case where the enrollment is more, in terms of RT, there may be additional teachers, the Act provides. And herein, at the time of provincialization, there was 150 students. So 2 teachers have been provincialized. Now, Ayesha Siddiqa was provincialized on the basis that it was an ME madrasa. So her subject is Arabic. So,
Show me from
yes.
where are you making this submission?
No, her subject
No,
is
no, no.
Arabic.
This written here. From
No,
where are you making
the
this
minors is
submission?
not there.
Then
Yes, 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 but the
here.
subject
Subject is of
here, Lordship.
immaterial because the subject
her
concern
subject is
would
Arabic.
come
And
in the three posts. That
Hindi is
only.
Lordship is special subject. My submission is that in the event
Sir, I'll accept your submission, but show me the basis for that.
the basis, no, actually recognition or the recommendation criteria. Permission recognition is not here.
If it is not there, it's not there. Finished. We'll interfere. You try it in the appeal.
Just a minute, Your Lordship. Just 1 minute, Lordship. Let me go through it.
You go through that as per your convenience. 30
Lordship.
Lana Council for the
Lordship.
parties at length. Hearing
86.
remains inconclusive, registered to listen matter again
Just
on
a minute,
28/4/2026. Try to develop. I'm dismissing it on that day.
On 26, Lordship.
28.
28, Lordship. Yes, Lordship, I shall try to satisfy Your Lordship.
And if you want to get my notes, if you want to get everything, and I stopped you, but you can still argue that point. And I'll be the most happiest person to record that. That for every teacher language, there will be one teacher. Hindi, Assamese, Boro, Bengali. How many teachers are there? For every one you will sanction a post, I'll record it.
Lordship stopped me in
I should not have. But I do not want you to make a wrong submission. And you show me the basis, you take the order.
Yes,
or
Lordship.
Mr. He is getting it. And you confirm whether he is working as an headmaster by an order of the government. Just get a material. And you also get that.
Yes. That I'm sure. He is tutor. Nobody has been appointed as headmaster in any of this.
Yeah.
Mr. Beria, I've gone through it. Now, this relaxation had brought in others also, in addition to the respond number 7. Many have come in, maybe. Now, I cannot segregate that Uttarakhand is one, the others are one. The law, if I apply, has to apply to the root. That means that resolution that they have taken and the approval of the DG, I'll have to set aside. Once I do that, I'll be interfering with the appointments of all those who have come in and then got recruited. They are not before me. I cannot limit it to respondent number 7.
Your Lordship, only 13 candidates were qualified. Their appointment itself is illegal.
Where are those? Now if I interfere...
And my grievance is only for
No,
the
no,
state
you
of
cannot
Uttarakhand.
be. It cannot be because if I lay down that law, if I hold that in that line, then I'll be saying that the recruitment process is bad. Although Tej Prakash does not say that. Tej Prakash has distinguished between essential criterias and criterias in the procedure of selection. That I'll handle. But now you reply. Your writ petition would not be maintainable on that point because if I interfere with the DG's approval, I'll have to do that. Then I'll be indirectly terminating the services of the others who had come in through that way. And they are not before me.
Your Lordship may kindly take up this matter tomorrow, day after tomorrow.
Thursday.
I'll go through it.
Do one thing.
Yes.
There is nothing else here.
Yes.
Those 3 pages.
Yes.
Page 17, 18 and 19. Give me yours also.
Yes.
Third, the learned counsel for the parties at some length. Mr. M. Beria, learned counsel for the petitioner, submits that he be granted time till, we'll have it on 5/5/2026 for making further submissions. Prayer accepted. Registry to list this matter again on 5/5/2026 for further hearing. Itu ready. You just give me that copy.
madam.
Now,
Yeah.
on the next day, you give me.
Yes, ma'am. Master.
Mr. Beria, these two aspects.
I have read somewhere, this court has the power to mold the relief.
I cannot, I'll not, because if I declare a law thing to be bad, it will go to the root of that. I cannot.
But that thing
Get
itself
me,
was
get me.
bad.
Educate me, no problem. Welcome.
Much of it.
Yes.
And I want to withdraw this matter, my lord. It has become infatuous. This is Madrasa provincial.
Now you are a normal school or a
normal school, my lord. We want to claim the benefit in 2017 Act, my lord. Liberty may be granted, my lord.
Mr.
A.W. Aman.
A.W. Aman, learned counsel for the petitioner, submits that the Assam Madrasa Education provincialization of services of employees and reorganization of Madrasa educational institutions Act 2018 has since been repealed. He submits that the school of the petitioner, now being a normal school,
my lord,
would be required. The eligibility of the teachers working in the petitioner school, so by the petitioner school, in the petitioner school, would now be required to be considered for provincialization of their services under the provisions of the Assam 2017 Act. So, in view of the above, he submits that he be permitted to withdraw the present petition to approach the respondent authorities for praying for consideration of the cases of the eligible teachers of the school, petitioner schools, no?
My lord, schools.
Petitioner schools under the provisions of the Act of 2017. Prayer is not objected to by Mr. B. Kaushik, Learned Standing Council, Secondary Education Department. In view of the above submissions of the Learned Council for petitioners, the present petition stands dismissed on withdrawal with liberty to the petitioners as grateful.
Grateful.
All right.
Review petition.
Oh. So this is review petition seeking review of the order dated in
Now, you say that we had only considered one aspect, Vijay Sankalp's decision, and that he has got less than 60, that will be not a bar.
Yes, Miller.
But now you say that he has also taken the relaxation of age.
Yes.
But the law is has been laid down.
The law now has been changed.
No, it's been laid down. What has said, if the recruitment rules does not permit, then migration is not possible. If the law recruitment rules permits, there is no bar.
Show me your decision.
Yes, Miller. Para 32, my lord.
After this, there is one more judgment.
Yes, Miller, Chaya and others, Miller. They also the same propositions have been held, Miller. Where a reserve candidate, Miller, para 32, would avail relaxation in the fees upper age limit to participate in open competition with general candidates will be recruited against the unreserved seats would depend on the facts of each case. That is to say, in this event if there is an embargo in the recruitment employment notification, such reserve candidates who had secured higher than the last secured.
Chaya's one latest one.
Chaya, my lord, I have, my lord, copy, my lord. I will report in the live law, my lord.
This will be covered by the 18 rules. 2018 rules.
Yes, yes.
There is no bar in the there is no bar for migration, and the advertisement also doesn't permit. It doesn't say there is a bar.
Well, this is reported, my lord, in
Chaya, no?
Chaya.
Yes, yes.
Chaya and other the state of Maharashtra. It's been reported in live law. The neutral citation is 2026 INSC 2277.
2000?
226.
INSC?
2026 INSC 277. Chaya and others versus the state of Maharashtra.
You are contesting for which post?
My lord, it's a post of
Political science, my lord.
political science, my lord. Teacher, my lord.
Bengali medium.
Bengali.
Postgraduate teacher.
Postgraduate teacher. PG
The
teacher.
citation is my SSC online session, my lord, 2026 SSC online SC 457.
2026 SSC online?
SC 457.
457. SC on the person.
What years ago?
Yes. ARF report 1. Because this relaxation doesn't affect the merit. It's only qualifying criteria, enabling this person a level playing field. That's what it does.
So, where is the relaxation for the reserve community candidates coming into being if it is not provided in the rules?
It says, but Chaya says even if it's silent, then also it will not be like the migration.
How do you get that relaxation?
Which relaxation?
You got a relaxation.
Yes, Miller.
Right?
Yes.
From where? Rules don't provide for that.
No, but SC category candidates, they're eligible to.
From where? In the rules, it is not there.
In the advertisement is there, Miller.
Let us see the advertisement.
Page 37, my lord.
Writ petition.
Yes, Miller. Page 37A, my lord. Page, yes, Miller, in the review petition, it's page 33A, my lord. It's a part of the writ petition.
Okay, fine.
A candidate must not be so-and-so, so-and-so. And my lord, open category, 40 years for ex-service, 40 years for...
Where are you reading?
Page 37, first, my lord, first line, my lord. Advertisement, my lord, then this side, my lord.
E, my lord. Serial number E.
Serial number E, my lord. On the other side, my lord, of that margin, my lord, that... 37A, my lord, annexure 1. Advertisement. Then the opposite side, my lord. E. First line. A candidate must not be less than 21 years of age and not more than 38 years for open category, 40 years for ex-servicemen, 41 years for OBC, OMOBC, and 43 years for ST, ST, SC, STP, STH, and 48 years for persons with disability as on 1st January 2022. So, according to that, she was allowed to participate. Otherwise, she shouldn't have been allowed to participate in the process itself.
No, not on that. From where did you get it? That's what I wanted. Okay. Yes, Mr. Khatonia.
I would like to go through this judgment, my lord.
You go through. Third, Learned Counsel for the parties. On the prayer of Mr. N.J. Khatonia, Learned Counsel for the review petition. Restrict to list this matter again on 7-5. 5?
7-5.
Have you filed a contempt?
No, my. No.
Mr. Das.
Lord, sir.
Have you filed an affidavit here? No. The IA will take care.
I will take care of it.
So we'll hear the whole matter. We are hearing the whole matter.
My lord, I want to file one affidavit, my lord.
That already chance was given to you. You have not filed.
My lord,
17.3 itself chance was given.
Yes,
you have not filed.
My lord.
And why did you not circulate a memo? We have come reading. So we'll have to take it up.
My lord, actually I had sought for permission from my respected senior, my lord. I didn't get the consent, my lord.
Lord, even on the last occasion, this honorable court told him that don't drag the matter further. That was the last. That was the last.
We are not permitting the dragging of the matter. We are considering it today.
My lord, just one short date next week, my lord. I am getting some.
I'm sorry.
documents, my lord.
You were given a chance. Now tell me,
Yes.
your cases was made that one of the colleagues of yours,
Yes.
he was continuing.
Yes.
Now they have come up and filed an affidavit saying that he is not longer.
Yes.
So that is gone. Once the whole post has been abandoned,
Yes.
the subject is not being taught there. Discontinue. What is the law which you want to rely, which says that they will have to continue with you?
My lord.
Resignation.
Will have to continue with you.
My lord.
Where is the law?
One point I would like to point out, my lord, from the IA which my respected senior has filed. My lord may kindly have the IA filed by my respected senior 3395 of 25, my lord. Page 15, my lord. 15. May I read, my lord? Is a 27/6/25 letter issued by the principal Jagiroad College.
This is your termination. We have seen
This is
it.
not my termination, my lord. This is the termination of respondent number 6, my junior colleague,
Okay.
who was a colleague.
Then he was again engaged.
Again engaged, my lord.
Engaged on for 89 days.
Yes,
89 days.
And that is also now not there.
my lord.
That is also
He
gone.
has resigned also.
My lord. My bone of contention is, my lord.
Show me your right, Mr. Das Sharma. How is your right vested in you?
My lord, my termination was itself illegal per se, my lord.
Per se. Show me that.
My lord, may kindly have the 27/6/25 order, my lord. Page 56, my lord, of my writ
Page
petition.
of the writ petition. Page 56.
My lord, by this order, I was terminated, my lord. My lord, on 2 counts, my lord. One being that there was low intake of students, my lord. And one
It is gradual dropping of emoluments in the last 3 years because of reduced number of students.
Yes, my lord. One is that, and one, my lord, because of financial crisis, my lord. 2 points, my lord. Now, my lord, if my lord has page 52 for a moment, my lord, with 52, with regard to the finances, my lord, regarding the said program, my lord. My lord, here, my lord, this makes it abundantly clear, my lord. For my lord, this program, my lord, if I may read, my lord, page 52, bottom portion. If we decide to provide a basic pay of rupees 57,700 per month for the faculties as per UGC and rupees 20,200 for non-teaching staff.
Show me that this money was allotted to the college.
My lord, that the respondent authorities can only bring on.
No, where is your assertion that this money, this is just a proposal.
Yes, my lord.
Where is the assertion that this money was in fact released to the college?
Here, my lord.
I know that you cannot know.
Yes,
but where is your assertion that this money was released? Then we will ask them.
Yes, my lord.
You tell me first. Where is your pleading to that effect? Where is your pleading?
Yes, ma'am. My lord, no specific pleading that the amount has been released, my lord.
Just pick up a page somewhere and where is your pleading that they have the money and they are misappropriating it by stopping the course? To me, that much only. Nothing more is required.
Yes. My lord, but the whole, my lord, the way I was terminated, my lord, just because I had given a dissenting opinion, my lord, on the same day, my lord. In fact, my lord, my lord will have page 28.
Mr. Counsel.
Yes, ma'am.
This wing of the college, this section of the college is not recognized by the government till date.
My lord, the Jagiroad College teacher.
Jagiroad College is recognized institution, but the BVOC course is not recognized by the government.
Yes, ma'am.
Then
my lord,
how is a writ maintainable? How is a writ maintainable? It was something they were paying you.
Yes.
And it is their statement even now that the amount is paid to you from the admission fees of the students. Now the students have gone down, we can't pay you. You have not even countered that.
That is what I wanted to counter.
You had, we had given you an opportunity. You can't take that as a handle to do it when you want to do it.
Not only one date I am seeking.
Okay,
As
tomorrow.
my final opportunity.
Tomorrow.
My lord, sometime
Thursday.
next
One
week.
day you want? Thursday.
My lord, one date, my lord, next
Thursday.
Thursday. Documents were available.
You were having time from 17-3. What were you doing?
My lord, there was a bereavement in the family of my client. That is why. That is the problem. I had sought for the same, my lord.
But the learned counsel for the parties at something. Mr. P.R. Sharma, learned counsel for the petitioner. Yep, Marivade, petitioner. How much that? The affidavit, which the additional affidavit, that reply to the affidavit filed by the, reply to the rejoinder to the affidavit filed by the respondent number 5 was not permissible to be brought on record inasmuch as there was a bereavement in the family of the petitioner. He submits that the said rejoinder would be filed on or before 30/4/2026, registry to list this matter again on 5/5/2026. It is provided that no further adjournment shall be granted to the petitioner to file the rejoinder to the additional affidavit filed by the respondent number 5. Registry to list this matter again on 5/5/2025 for further hearing.
Will be record of presence.
Dr. A. Chamuha and your name. And Mr. R. Sheikh are present for their respective respondents.
5th of May, no?
Obligement.
Lordship please to come to the impugn order, Lordship. That Lordship will find out.
What to do? Why? His provincialization was challenged before this.
I do.
Don't ever file.
Second.
Forget it. On the prayer of the Mr. B. Kaushik, learned counsel for the petitioner. Learned standing counsel, secondary education department.
Elementary.
Elementary education department, registry to list this matter again on 30/4/2026. You get a copy. Very simple.
No, I've seen from the second file. Otherwise,
why are you not? Because the order, it was under stay.
And it was withdrawn then.
No, this court said this will continue if you approach before the court within a particular time. They approached. Let us say the interim order was continuing. It would have merged into the decision of the
tribunal.
No decision from the tribunal has come. The challenge negated. Why will he not get it?
No, my lord, the challenge negated for dismiss or default. Now, my lord, whether it has been restored or not, well, we don't know because they have not made them ma party in this repetition.
That is something you should, because see, Mr. Kaushik, that is something you can always get a information from your inspector of schools or your DEO. Have they restored that file?
No.
That I don't know. Because
already terminated.
And moreover,
that the learned counsel for the parties. The learned counsel for the parties on the next date of listing shall apprise this court as to whether the proceedings before the jurisdictional election tribunal in election
Educational tribunal.
Educational tribunal. In educational tribunal petition number 4/2016, which was dismissed for default while order 31/3/2021 has since been restored by the appellants therein, by the petitioners therein. Also, registry to list this matter again on 7/5/2026. Just get that information, rest will fall into its own place.
Your Lordship.
What, who are you?
My lord, I am the academic in charge, my lord.
Yes, who is appearing for the state? Yes, what is your stand?
Affidavit needed to be filed, Your Lordship.
No, needed to be filed, not filed. It's in
Not
the hearing
filed.
stage. Will not permit you. Why a proceeding was not instituted against her? If there is so much of allegations against.
কোনে appear কৰিছে এটা? হুম? Orders ত আহিছে ন?
My lord, in the earlier occasion, it was kept as part-heard matter, Your Lordship. It was kept as part-heard item, Your Lordship. This time it is released from part-heard, Your Lordship.
This has been released from Pater.
Yes, Your Lordship. Your Lordship.
Not released, my lord. On the last occasion, it was not taken up because of
Paucity of
time, my lord. So a date was given. And on the last occasion, Your Lordship only wanted to.
10/3/2026. Yes, I forgot. Yes, madam. What is your instructions?
Only the steps taken by the department.
Yes, 10/3/2026.
পংকজ কৰিছে ন?
PP Dotto. PP Dotto. PP Dotto.
Am I allowed to call him, Your Lordship? PP Dotto appears on the last occasion. Huh?
Then why did you appear?
Your Lordship, I am also not
Rosalie.
sure, Your Lordship. Question.
Call him.
Yeah.
No. You know, mind. You have nothing to say that there is no proceeding against you. Allegations may be there, but how can you be deprived? That's the only thing.
Yes, yes. Your Lordship.
And Mr. Hassan is a default entry.
Yes, sir.
She is not there, so if we put her back, you out. That's all. But I want to know why departmental proceeding was not instituted. So much of allegations, my good God. He should have been dismissed by now. He or she? He.
He.
Nothing. That means all those are bogus. He is available.
Due to his stomach upset, Your Lordship,
So-
he has to leave, Your Lordship.
Oh.
Your Lordship, and already reminder letter has already been given from his
Oh, that
side, Your
means
Lordship.
the respondents are not responding to your letter.
Yes.
Okay.
Oh,
Lekha. Hey, Birospotibar ello.
and-
If I don't get the instructions at 10:30 in the morning, 2 o'clock, whoever is to give you that instruction will come personally here. Mr. PP. A prayer is made on behalf of Mr. PP. Learned Standing Council, elementary na second? Elementary education.
Secondary.
Secondary education for an adjournment in the matter on account of personal inconvenience. Prayer accepted. It is submitted that the instructions for answering the query raised by this court via the order dated 10/3/2026 has not been furnished to the Learned Council in spite of reminders being issued to the respondents in this connection. It is provided that on the next date of listing, if the said instructions are not furnished to the court, if the query raised by this court noticed herein above is not answered by on the next date of listing, this court would require the personal appearance of the authority who was required to furnish the said instructions to the Learned Council. Registry to list this matter again. By slip code. Thursday.
24.
26.
10:30.
24.
10:30, come and tell me you have got the instruction. Or we'll have him at 2 o'clock here. Too much.
23.
24.
Kylie election.
Wait till